So now you can hear me?
I can hear you, but do you have a video too capability?
I do, but doesn't seem to be working right now.
All right. Well, we'll go ahead and get started anyway.
Okay. You don't need to see me.
Carol, wait just a second. Carol, you ready to start video? The taping? All right. All right, Mr. Valentine, if you would, please.
Yes. Good morning, fellow commission members, staff members, and I guess there aren't any guests, but if there are some virtually, today's date is the 22nd of April, 2021 at approximately 9:02 a.m. I'm Walt Valentine, Commission Chair. I will now call to order the meeting of the Tennessee Private Investigation and Polygraph Commission. Executive Director Cody Vest, would you please call the roll?
Thank you. Stuart Bain.
Present.
David Brown.
Present.
Robin Johnston.
Here.
Alan Russo.
Present.
Doug Shanks.
Present.
Walt Valentine.
Present.
Kendall Barham.
Present.
Charlie Bradley.
Present.
Let the record show that all commission members are present. You do have a quorum, Mr. Chairman.
Thank you. Next, we have a statement of necessity by Jesse Gentry, the Associate General Counsel.
All right, good morning.
Good morning.
Just going to pull that back up. This is the regularly scheduled meeting for the Tennessee Private Investigation and Polygraph Commission, which is taking place via video conferencing means pursuant to Governor Lee's Executive Order number 16 and extended by Executive Orders number 65 and 78. Meeting remotely is considered a reasonable measure to protect the safety and welfare of Tennesseans while ensuring government business may continue in a manner that is open and accessible to the public. All votes by the Commission will be by roll call. Notice of the meeting date, time, location was all posted on the Commission's website since September 30th, 2020, and the agenda has been posted on the Commission's website since April 15th, 2021. Pursuant to Tennessee Code Annotated Section 8-44-108B2, if a physical quorum is not present at a physical location of a meeting of a governing body, and in order for a quorum of members of the governing body to participate in the meeting by remote means, it may be acceptable if a necessity exists and a statement of necessity is read into the record. The determination must include a recitation of the facts and circumstances for which it is based. A necessity is determined by matters to be determined by the governing body that require timely action. A physical quorum is not practical within the time requiring the action, and that participation of a quorum of the members by electronic means is necessary. Based on the COVID-19 pandemic, a necessity exists that requires the meeting by remote means. The purpose of today's meeting is to discuss the meeting agenda, which was previously posted to the Commission's website, and voting on all matters will be done by roll call. Thank you.
All right, Mr. Chairman, before we move on to our business, we do have a guest with us this morning, our Assistant Commissioner, Alex Martin. I'd like to turn that over to him. I know he's extremely busy, and we appreciate him taking the time to pop into our meeting this morning.
Hey, Cody, thank you so much. Can everybody hear me okay?
Yes.
Hey, good morning, commission members, and appreciate the opportunity to join you and to speak to the group quickly. So as many of you know and have discussed in this setting, we're anticipating a change in structure to this board in the way that several of our programs are being run. I'm sure many of you are familiar with a bill that was brought forth by the administration to combine several of our programs into a commissioner-run program in the detections services area. We're excited about the efficiencies that's going to give us, but we're also extremely grateful to our board members who have served with distinction. I know many of you have served on this board for years and have been very attentive and diligent, and I just want to say on behalf of the department, and I know for Cody as well, we're very, very grateful to all of our board members for their service, and that we hope to continue engaging with all of you in this new phase of regulating the industry, but also protecting consumers. And just as a personal aside, for those of you that don't know, before I joined the department in this role around the first of the year, I worked on appointments in Governor Lee's office. So from a personal point of view, spent a lot of time in engaging with folks outside of government and asking them to serve on behalf of the administration. So sincerely, thank you all for the service that you've provided, and hope to continue engaging with all of you.
Oh, thank you, Assistant Commissioner. We appreciate that.
Thank you, Cody.
Walt, we want to pick back up where we're at now?
Okay, next item for approval is the agenda. I'd like to ask each commission member if you've received and had time to review a copy of the agenda. And if so, is there a motion to adopt this agenda?
Motion
Mr. Brown,
made by me.
Okay, there were several of you. Was that Stuart Bain that made the motion?
Yeah, Brown second.
And Brown did a second. All right.
Okay, any discussion? Hearing none. All in favor, would you call the roll, Cody Vest?
All right, Stuart Bain made the motion to accept, and it was seconded by David Brown. Stuart Bain,
Aye.
David Brown,
Aye.
Robin Johnston,
Aye.
Alan Russo,
Aye.
Doug Shanks,
Aye.
Walt Valentine,
Aye.
Kendall Barham,
Aye.
Charlie Bradley.
Aye.
Motion was made to approve the agenda.
Motion carries.
Yes.
Next on the agenda is minutes. Approval from the Education Committee and Commission meeting. Has each commission member received and had time to review the copy of these minutes? And if so, is there a motion to adopt these minutes?
Alan Russo, I move adoption.
Charlie
Okay.
Bradley second.
Okay. Executive Director Vest, would you call the roll?
Yes, there was a motion made by Alan Russo and a second by Charlie Bradley to accept the minutes. Stuart Bain,
Aye.
David Brown,
Aye.
Robert Johnston,
Aye.
Alan Russo,
Aye.
Doug Shanks.
Aye.
Walt Valentine,
Aye.
Kendall Barham,
Aye.
Charlie Bradley.
Aye.
Motion carries.
Okay. Next on the agenda is the legal report by our staff attorney.
All right, great. The legal report will start with the first case on here, which is complaint number 2021005271. Summary is that the complainant contacted the respondent in January 2021 regarding a missing persons case. The complainant stated the respondent's retainer was $3,000, but she was able to pay him $2,000 for him to start the case towards the retainer. The contract clearly stated that the retainer between the parties was $3,000 and non-refundable. The complainant has paid $2,500 towards this retainer. The complainant's issues are that she felt like the respondent was not appropriately responsive in giving her updates, and that she paid for these services without receiving any results. The complainant did not dispute that the respondent had run several reports, followed up on addresses found, visited shelters, and the coroner's office. The complainant also acknowledged that the respondent responded to her request for updates and provided an itemized bill when requested. Based on the terms of the contract between the parties and services performed, there are no grounds for misconduct from the documentation obtained in this case. The recommendation is to close.
Do I hear a motion?
Commissioner Brown moves that we accept council's recommendation.
Is there a second?
And seconds.
Okay, it's been moved and seconded to approve that legal report. Any discussion? Hearing none. Executive Director Vest, would you call the roll?
Yes, I'm sorry, I didn't hear who made the motion.
Commissioner Brown.
Brown and Johnson seconded it, right?
Yes.
All right. Stuart Bain,
Aye.
David Brown,
Aye.
Robin Johnston,
Aye.
okay, thank you. We had a little static there. Alan Russo,
Aye.
Doug Shanks,
Aye.
Walt Valentine,
Aye.
Kendall Barham,
Aye.
Charlie Bradley.
Aye.
I believe the motion was to agree with council to close the complaint number 1. Ayes have it, Mr. Chairman.
Right. There's one last case in this legal report. It's complaint number 2021-004701. The complainant stated that the respondent was advertising for private investigation services in Tennessee. The complainant indicated that the respondent's site map showed it was advertising in every major city in Tennessee by changing its listing in the site map to match that the one that was located, or to match that it was located in different cities. The respondent's website advertises for services including background checks, surveillance, locating missing persons, and other investigations. Our investigator made contact with the previous employee of the respondent, who had also built the website for the company. This individual stated that the respondent's company is based in Arizona and that the respondent only operates in Arizona, but if they are contacted by customers in other states, they contract the work out to a licensed private investigator. Our investigator was then able to make contact with an individual who stated he was the owner of the company, and he also stated the business operates in the same manner as the previous employee indicated. Our investigator never received a written statement from these individuals associated with the respondent company, nor did he receive a statement from the complainant. The respondent's website makes it appear specifically to target and advertise for services to be performed in Tennessee. However, there was no evidence of any actual services being performed by the respondent in the state. The recommendation is to send a letter of warning and cease and desist letter.
Okay, you've heard the recommendation. Do I hear a motion?
I have
Alan,
a question, if I may.
After we have the motion,
Very good.
I move to accept recommendation of council. Alan Russo.
Okay. Doug Shanks seconded. Okay. Now we have discussion.
Yes, just I wrote a note to myself when I reviewed this yesterday, and I would like to read it. If the Arizona company is getting / taking a cut with the subcontracted Tennessee licensed PI for services performed in Tennessee, it seems to me that is generating income from services performed or provided in Tennessee. Therefore, I think a letter of warning to cease and desist is quite appropriate.
Okay, any further discussion? Hearing none. Executive Director Best, would you call the roll?
Yes, sir. Looks like we had a motion by Alan Russo and a second by Doug Shanks to accept the attorney's letter of warning with the cease and desist. Stuart Bain,
Aye.
David Brown,
Aye.
Robin Johnston,
Aye.
Alan Russo,
Aye.
Doug Shanks,
Aye.
Walt Valentine,
Aye.
Kendall Barham,
Aye.
Charlie Bradley.
Aye.
Motion carries.
Any further legal report?
Nothing further. Thank you.
Okay. Do we have anyone wanting to appear before the commission? Executive Director Best.
I don't show that we have any appearances today, Mr. Chairman. We can go right down if you'd like into my administrative matters.
Okay.
The first thing is the monthly report that you get obviously every month. You got January, February, and then we have March. Jesse and I, as you know, meet very regularly. we got down on March the 21st. We did have our March 24th, excuse me. We did have our monthly financial meeting as well. We still have the vacancy with Alan Russo, who's not been reappointed but serves until. And then we still have the commission vacancy that wasn't that
Larry Flair.
Larry Flair. Yeah, I'm sorry. You know what I was going to call him, so I was doing my best not to not to say that. I just don't know why I do that, but I do. I've always been a big wrestling fan. Okay. We don't have any comments on that. We'll go down to the budget, and I need to tell you about your budget here. I think the last meeting you might have gotten your December report. In January, you were in a negative of $1,712. We lost revenue for some reason for that particular month. But in the month of February, we picked back up for 7,253. And then for a total so far for the end of February, you're carrying a positive balance of $35,794. So we've done quite well there. Legislative update. I might just turn that over to Jesse. You want to give them just a little brief rundown on that, Jesse? Or I can.
I can do that. I think the bill that we've all discussed a little bit, and I believe Director Vest had provided a copy to everyone already, but it would be House Bill 0781 and Senate Bill 0770, their corresponding bills. That bill is actually passed in both the House and Senate. So at this point, Governor Lee is considering as to whether or not he'll sign it. At this point, it has not been signed that we're aware of, unless he's done something this morning. But once that bill is signed, if he ends up entering it, it will terminate the PI commission, and it will make it a commissioner-run program under the Department of Commerce and Insurance. There's a couple things under this bill that I just wanted to highlight. If you've received a copy of it, I'm sure you've seen that there's references to locksmiths, alarm companies, and private security as well. So there's, it's pretty lengthy, but the section specifically dealing with the private investigation industry does make a few changes that are noteworthy. One, it removes this commission effective June 30th, 2021. This industry will still be regulated, and the bill does create the Department of Commerce and Insurance's ability to create an advisory committee as well to help with the regulation of this industry. This bill also does remove the requirement that a licensed private investigator would have to be affiliated with a private investigation company. Now, it does not remove, this is something I want to bring up, it does not remove the private investigation company license requirement. It does not remove discipline for that. So there could be a situation, if you're a solo practitioner out on your own as a private investigator, you would not have to also have a company license. But if you're operating a private investigation company without a license, that's where discipline could arise. So I think that is something, I think there's been a little bit of confusion there, but I know there are a lot of private investigators who are out on their own. They've got their own company. They're the only private investigator there. So at that point, they would not necessarily have to be affiliated with the company, but that is something to be aware of. So for anyone that is considering if they're going to change their business model, you may want to consult with a private attorney just to discuss, your formation of your business, an accountant, then whoever's providing your insurance as well, just to make sure that everything is as it needs to be for this industry. And then the last thing that it would do, and the last thing I guess would just be that committee then, which you'd see at the end. So if this bill is signed, it would take effect in terms of termination of the commission effective June 30th, 2021. So if it is signed into law, this would be the last commission meeting. Director Vest and I have discussed that we're going to have a meeting with our assistant commissioner as well as some others within the department to determine what any type of committee would look like and how that would meet. But at this point, the bill has not been signed. So, Director Vest and I were discussing this earlier today. We would be moving forward as of today, operating, as business as usual. But once this is signed, I guess she would reach out to you all to let you know that we would, how we'll be moving forward. So are there any questions or any discussion on that?
An unrelated question, in a sense, is I wanted to ask during the associated with the budget review, and this might be appropriate with this new legislation. Have the licensee PI license numbers continued to trend down, Cody?
Not, sure, to answer your question, no. There has not been a big decrease. I mean, as you can see, we had a problem in January. One of them took in a little over $9,000, but February we took in 16. So if you look at the budget, it looks like we're running somewhere between 13 and 15,000. But I believe most of that, if you got delved into that, is your renewals. But we are seeing new applications coming in with for private investigators. We are maybe thinking that this law goes into effect. We may see more private investigators. We will talk to each investigator that makes, or each applicant that makes an application, and explain once you lose your company affiliation, then it's all on you. So if you get sued, it's you personally. So there are certain steps I'm sure they're going to need to take. So we will discuss that with each person that makes an application. But right now, I don't see a large decrease in applications or renewals.
And applications for polygraph examiners?
That's no, sir. That kind of stays pretty even. I mean, I gain one, I lose one. They're in the 50s.
Thank you.
You're welcome.
Anything further under administrative matters? Executive Director Vest.
Yes, sir. I do have some correspondence, but we have a gentleman who just sent us a chat who wanted to speak to the commission. So I think I'll just go ahead and stick him in there. And with this chat, it doesn't really, is this Mr. Young? Are you located out there?
I am. Can you
Mr.
hear
Young.
me?
Yes, sir. It says here that you'd like to take a quick moment to tell about a scam that is happening or has happened.
Yeah, and I thank you for allowing me to speak quickly on that. And it happened within the last month. I didn't know by sharing it if you could maybe put it out to all the private investigators across Tennessee. Maybe it's something that they've experienced. Basically, we got a call from a lady in Kentucky who asked if we had a gentleman named Kenneth Schmidt with Covert Results, my PI company, and we said no, we did not. So then she called the police, and I ended up calling the lady and asked for a little bit more information. And she said that basically her son had received, or thought he was texting a young female, and some pictures were swapped back and forth. Well, then a gentleman posing as the father called and said, I have a PI. We're going to, prosecute you unless you pay us $1,500 or something like that. So it was just an extortion scam. But the lady was telling me that the guy portrayed himself as a PI with my company. Well, I ended up calling the phone number, and sure enough, the guy's voicemail says that he's with Covert Results. So as shocked as I was, I thought that the voicemail itself, because of my time in law enforcement, I felt like it was a scam from jail. So I contacted a friend with TDOC and worked that angle. And then the phone is still working, although he changed the voicemail. But I just wanted to put that out there to say that, people, there's all kind of scams out there. And ironically, Metro Police had issued a scam alert where police officers' names were being utilized to portray, during the scam, like people were calling, demanding money and saying, I'm a police officer, and actually using the real name. So I just thought it was a good PSA to put out and just kind of be aware that people are, utilizing real PI companies and trying to extort folks. So just wanted to put that out there.
All right, Mr. Young, thank you. Anybody have any comments on that? Have they experiencing the same thing or anything? Well, okay. Well, I can say thank you, Mr. Young. Yes, sir. We will look into that also. If there's no questions on that, we'll move down to our correspondence. Mr. I pronounce that Glee, or it could be Klee. Al, Klee, with KGI Investigations. As you know, over the course of the year or so, I have been talking about ideas of how to get more people into this industry. Well, this gentleman sent us an email, and I wanted to share it with everyone. He's taken the time to sit down and think about different ideas. He's a retired U.S. Lieutenant Colonel. Now he's a private investigator, has his own company. Is this gentleman with us this morning? I didn't see him on our list. Okay, so I'll just do this. I may not have all the email here. Mine actually starts with number 5, establish different levels of license. I know there's more to that than that. Shauna, do you have that whole email? Like I said, I apparently didn't get all the email.
Let me
I
let me
believe
double
it was-
check, Cody.
I believe it was sent correctly. I have it.
Oh, it does start with number 5?
No, it starts with number 1.
Okay, then that's what I don't have. I don't have the whole. Well, if you have that, would you mind reading one at a time till I can get down to number 5 there, Stuart?
I would not mind at all. And in the Tennessee vernacular, they might say, I wouldn't care to.
Okay.
Let's see. Number 1, develop a recruiting program similar to what the Department of Defense does to include high schools and colleges. We've discussed that before.
Yes.
2, develop a junior sleuth organization hosted by various PIs or PI organizations or associations, I might add, who take young men and women under their tutelage. 3, create a troops to PI program, similar to troops to teachers program. And 4, give military veterans a reduced rate to become a PI. That's 1 through 4. Executive Director Cody.
All right, thank you. Number 5 is to establish different levels of the license. Class A, Class B, Class 3. C, excuse me. I know in other states there are all kind of different licenses and different levels. Number 6 is after Class A status has been achieved, move the requirement to either be a business entity or with a business entity. So the statute might take care of that one. Number 7, consider a qualified immunity law for PI similar to what most LE falls under. Thank you, Shauna. Number 8, establish and or sponsor insurance for PIs that protect PIs from losing their property, personal property, and or monetary resources. Number 9, separate process servers out of PIs by creating a special licensing similar to PIs if the process server is not already a PI. Well, in response to number 9, years ago when I first started with, they were talking about putting on process servers, but that has never came to fruition. Where are we at? Number 10, establish a method that helps transit retired police officers and detectives into PIs easily. Well, I don't know how much easier it could be. You just make application, take a test, and you got it. You know, I just didn't really understand that one. But 11 is establish a method that helps those with the degree in criminal, I think the word is justice, to obtain a PI license more easily. Base the level of education with the class of license. Class C at the associate level, Class B at the bachelor's level, and a Class A at the master's level, which concentrates in political science, investigative strategies, law, criminal justice, forensics that help one acquire the skills necessary to work as a private investigator. Number 12, a little hot spot here. Provide a wallet card that is professional looking and the same size as your driver's license. Okay, been trying to do that for years. Okay, the current card is difficult to read and does not fit inside a standard wallet or standard credential holders. Well, let me make a statement right here. We do have the new printers. I have been asking for these printers for years. where you're going to be one of the few professions, it's just my professions, that these new cards are going to be printed from. We've already seen that it's a silver card. It does have a hologram. It does have the state seal on it, and it's a very pretty card. I'm working diligently with IT with that, but they're still writing the program. So, but just my professions are the only ones, well, I think court reporters as well, will have
Well,
these
that makes
particular
sense.
IDs. Right. I think so too. Thank you. And number 13, provide an approved design for Tennessee licensed PI badge with license number and possible provided upon being fully licensed or indicated location to purchase one with submission of a copy of the current license. I don't know hardly too many PIs out there that hadn't already had a badge made all on their own, but our statute, your statute does not address that. But I want to thank this gentleman for this information, because I've been asking for quite a while to get some different ideas. Stuart had given me some ideas where, and some of these are pretty feasible. Some of them I just probably couldn't do on my level anyway. So I want to thank the gentleman for sending that in too, and we will be looking at that. Was there any questions on that correspondence there, or any comments?
Just a comment on number
Okay.
11, which is the establish a method that helps those with a degree in criminal justice to obtain a PI license more easily. I believe our statute rules already cover that. Maybe not the class C, B, and A, but if you have demonstrated the educational levels associated with the aforementioned subject areas, you're in.
Yes, there's a couple of things on there that I think we've already done. I am working with the school system right now for private protective services for individuals who are taking criminal justice in high school to be a security guard. Of course, they have to be 18 years of age. We're proud to tell you that they started with Davidson County, and now the program is going all over the state of Tennessee for all the schools. It is all the schools that are offering a course in criminal justice. So we're working closely with the school system on that, and I have and will be talking with them about the possibility of PIs.
And anytime you want a licensed PI to get to a school system to speak on the subject of forensics, just ask me.
I appreciate that. But doesn't your statute require you to be 21? Yes.
I believe that's the
You have
case.
to be 20, you have to be 21. So we may be talking about college. We may not be talking about high school, but it is something that we probably could go and address and they never even thought about and may want to look into that area. So I'm working with Sloan on that with the Metro school system, but like I say, it's all over the state of Tennessee, and we're proud of it being a part of that. If you're ready, we'll go down. If no other discussion, we'll go ahead and go to our education review. As our education committees, Walt Valentine, David Brown, Doug Shank, Stuart Bain, and Alan Russo. Have you, have you gentlemen had an opportunity to look over the courses? Give me any idea what we're doing? All right. If we will, let's just take that one at a time then. The first one, if you look at it, is Legal and Liability Risk Management Institute. They wanted 14 hours for continuing education. Education Committee, I believe we don't usually do that. We just do it for the length that they need, which is what, 12 hours?
Well, yes.
Okay, what do y'all think about that course? He has 2 of them. These are going to be online in courses.
I didn't have any issues with them.
Okay, the second one is the first one is cellular technology. The second one is introduction to interview and interrogation for new detectives. The first one he wanted 14 hours. The second one he wanted 6 hours. So what is the recommendation for the committee?
I think we only allow 12 hours since that's all we need.
That's my understanding.
And I have no issue with the 6 hours on the interview and interrogation for new detectives. I have no issues with that.
Okay, I think
I'm
what
good
I'm
with it.
hearing from the education committee is that we would accept that first one instead of 14 hours, we'd make it 12 hours because that's all you need. And then the second one, because this is the same company, we would accept that course for 6 hours. Is that what I'm hearing from the
Yes.
education committee?
Yes, ma'am.
All right,
Yes.
we ready to let's have a excuse me, a vote from the full commission to accept both of these courses by Legal and Liability Risk Management Institute. The first one, Cellular Technology, for 12 hours. The second one, 6 hours for the Introduction to Interview and Interrogation for New Detectives. Stuart Bain,
Aye.
David Brown,
Aye.
Robin Johnston,
Aye.
Alan Russo,
Aye.
Doug Shanks,
Aye.
Walt Valentine,
Aye.
Kendall Barham,
Aye.
Charlie Bradley.
Aye.
Ayes have it, and those two courses have been accepted. I had some questions about the next one myself, Education Committee. This was from Eric Neal. What is that, New Hampshire? Skip Trace and what we can figure out with a little bit of information he sent, he wants to be a provider. Well, I don't we tell them what they need and how they need to provide this to us. We don't exactly have a resume. He just says he's the owner of the company, Neal and Associates. He had another company, Affordable Financial Solutions. I mean, you can see through there. And that's all the information he gave to us. The person on the certificate, he did get permission to use her name. So that's just an example of the certificate. He's not the PI and she's not the PI. So he's asking to be a provider. What does what does the education committee think?
I think he needs to follow our procedures. First of all, give you what you're needing.
Do we have enough to look at that and make a decision on the provider, being a provider?
I think we need to ask the director and staff to further contact the gentleman and get some more information from him. Alan Russo.
Seems like we ought to have his qualifications to teach a course.
And I don't exactly know. He's got Skip Trace and how to conduct a bank locate. Well, he's going to have to be a provider, or else this would be for his individual. He's asking for 2.5 hours. So I'm thinking he wants to be a provider because he's not a PI, and the lady's not a PI, and this is just a course. So, is it okay with the education committee if we do put this? Well, I'll put this on hold and ask this gentleman for further clarification.
Alan
Yes.
Russo, I would agree with that.
All
Stuart
right.
Bain, I would agree with
Yes.
that. I would also offer the idea that the very skeletal course syllabus does indicate over 180 minutes of connected time, which does suggest 3 hours might be acceptable if we had enough information.
Okay, instead of the 2.5 hours, we would look at it for maybe possible 3 hours. All right.
That would be my view, yes.
All right, so I'm not going to ask for a roll call on that. What we're going to do is we're just going to table this one until I can get additional information, if that's all right with the education committee.
Yes.
Okay. All right, then we could go down to unfinished business, and we just have an item there for unfinished business, and I believe I'll turn that over to Jesse as well.
All right, perfect. I think if you recall, we had a question about at the last meeting about a young lady who works for a California company that runs background checks. And she was going to be moving to Tennessee due to the COVID-19 pandemic, and wanted to be able to continue to work for her employer and conducting background checks here in Tennessee for that company. They did tell us at that time, that everything would be through their California server and for their California clients and for this company in California. But we did send, I sent a list with 10 very specific questions just to follow up to get more information to see exactly what is going on with their company. They did say, when I asked how many employees would be physically located in Tennessee, they said it would only be one employee. I asked what type of work she'd be completing here. She said completing background checks using their California-based servers, and that all work is done online. She said they only conduct background checks and due diligence investigations for corporate clients. And then she said that they do not do any type of field work or insurance investigations, workers' compensation, criminal defense, or other traditional investigations. I asked whether her employees would have company equipment here in Tennessee. She said yes, a desk, chair, and computer. I asked whether or when that person will be located in Tennessee, and they said December 2020, which was actually before this email was sent. So it sounded like she had moved back here, while we were still discussing all of that. And I believe she is actually still here in Tennessee working. We asked how long will the employees be physically located in Tennessee, and she said they weren't sure. They had not decided long term what type of schedule they'd be using. And then I asked whether or not the employee physically located here would be conducting background checks on individuals located in Tennessee. And she said it was unlikely as most of their clients are located in California, but there are large companies, so they may hire someone from Tennessee. I then asked if the employee located in Tennessee would be conducting background checks for a client located in Tennessee, and she said no, all their clients are normally based in California. I asked whether background checks for these individuals or entities would be billed from a Tennessee address. She said no, all the billing still comes from their central California address, which was something they had asked about sales tax also, which is why I had asked that. And I asked whether or not they'd have any other ties to the state with their work, and she said no. And I did ask if there's anything else that she wanted the commission to know, and she did say that the employee had moved back here due to COVID-19 issues. So Cody Yvette and I talked about this a little bit yesterday, and we felt like the best course of action would be to just provide this information to you all. I have gone back through our statutes and our regulations. It does seem like, we know that background checks, if you're conducting those, are typically considered work of a private investigator, and you would be required to be licensed to be doing a background check. There is one exemption that I thought was pretty close. It's not necessarily completely on point, but if you look at Tennessee Code Annotated 62-26-223, there is an exemption for licensure for a person engaged exclusively in the business of obtaining and furnishing information regarding a candidate for employment to the candidate's potential employer, which it does sound like that's the type of work that they're doing for these companies. She didn't completely clarify that that's the only type of work that they're doing, but it does sound like that's the main type of work that they do. And then looking back at our definitions of who is a private investigator and what is considered unlicensed practice, it is typically work that's being performed here in the state of Tennessee by someone who's, and we have the definition of, if they're identifying the habits, conduct, business, or occupation of, or relations or character of a person. So, that's where we get that background checks would require a license. So looking at all of this, I think what we need to consider is that in the post-COVID-19 business world, it does appear that more businesses are going to be continuing to use working remotely as a way to sustain their business operations. A lot of businesses, even in Tennessee, have discussed continued policies to allow working remotely to, one, save money for the business, but two, also to have the employees have more flexibility. Looking at the law or legal industry, for example, this was a question brought up to the American Bar Association as to whether or not an attorney licensed in Tennessee could do work in another state, in Florida, for example. And the American Bar Association gave guidance to lawyers saying that if you're licensed in Tennessee, your work would be occurring in Tennessee, but you're just in Florida, answering your emails or working on your computer, doing phone calls, you're just doing that work because you're physically located in that other state, they were of the opinion that you're not committing unlicensed activity in the state of Florida by moving there. Obviously, that's not binding, but I thought from hearing that from another industry, that could be something to consider for guidance. Potentially, we may want to look at doing a rule change down the road to address this issue, because I think in this situation, this company is licensed in California, and this employee is someone who's just working on the computer here in Tennessee, sending that information back to California for that California private investigation company to do all that work. If they're not investigating people here in Tennessee, they're not investigating or doing work for individuals here in Tennessee, and this person is only here working because they would be normally in California. They're only here because of the pandemic or something else going forward. I think it's a situation where we may not want to pursue any type of unlicensed activity going forward, just because of the fact that this is probably where industries are going to be heading. And we may want to consider a rule change that would allow someone, maybe if you're working for a licensed company, for example, and you're only here either on a temporary basis or you're performing that work for that out-of-state client, that it could be considered an exemption from licensure. So I think that's something for the board to consider. If you all feel like this should be a violation or this should be something we pursue, we could establish a complaint and further investigate that matter. Are there any questions?
I cannot disagree with Mr. Gentry's evaluation. I agree with what he said.
Any further
I-
discussion?
I kind of echo that too. I mean, this is the day and age of what we're into. It's changed what we're used to. We got to adapt.
Any further unfinished business?
Well, I think
Wait,
I'd like to just add, I think a further clarification is appropriate going forward, as Jesse suggested.
Is in a rule change? Is that what you're mentioning?
Correct. Yeah, I do. That's what I mean.
Thank you. And I think that we could clarify that to say, if you're working for a license, I know we've got our reciprocity statute that discusses, entering into reciprocity agreements. Maybe we wouldn't necessarily have to say this is reciprocity, but saying that if you are working for a licensed company, you're just happening to be here, doing work that would be occurring in that other state, maybe that's where that exemption lies. So we can discuss some language for that at a later date, whether that's through a committee, if that bill does pass for that House bill, or if it doesn't pass, we can discuss it with the commission.
And that's great. If I were this company based in California and I had an employee based in Tennessee, does it not appear to benefit the California company to open a branch in Tennessee? I mean, it's so easy for that person based in Tennessee to expand background checks into the state of Tennessee.
I agree. That's a good point. We've got a lot of businesses that are now moving their headquarters, or at least their North American headquarters, to Middle Tennessee or the state in general. So that is something where if they did want to expand that could be beneficial to them. I think at this point, because she had mentioned when we told her that if this individual needed a license, it would need a company license here in Tennessee and then that branch office. I don't think that that's what they were necessarily intending to do, since it seems like it could be a temporary situation. But I agree that could be a helpful tool for these companies.
okay, so let me see what we're going to do. We're going to tell this company that they do not need a license for this individual who's working in Tennessee right now, doing this temporary work. That's the final decision, correct?
Yes.
Jesse, would we need a vote on that?
Let's do it. Let's do a roll call vote. I mean, because I will send
Okay.
her a letter. So let's go ahead and do a roll call vote. for
Okay,
that.
I'm gonna do a roll call vote to tell let me start all over. INFORTAL Worldwide, that they do not need a license at this time for the individual that is working temporary in Tennessee. So just the roll call, Stuart Bain,
Aye.
David Brown,
Aye.
Robert Johnston,
Aye.
Alan Russo,
Aye.
Doug Shanks.
Aye.
Walt Valentine,
Aye.
Kendall Barham,
Aye.
Charlie Bradley.
Aye.
The ayes have it. So Jesse, you're going to send them a letter, correct?
I will.
All right. Good. Write this down. All right. That was under unfinished business. We don't really have any new business. Don't have more education. I did want to tell you if the House bill is not signed, the merger bill is not signed, your next meeting will be July the 23rd, 2021, and it probably would be in the office. We're starting to come back into the building now for meetings somewhat, so that's a possibility that you would be coming back into the building. If the merger bill passes, I will call each one of you individually to let you know that it has passed. Like Jesse said, if it does, and this commission is dissolved as of June the 30th, but the actual bill goes into effect July the 1st. Is there any other business or anything else that anyone would like to talk about, speak about? I would like to tell, first of all, let me get my part in. I want to thank each commission member. I have reached out to other people that have served on the commission and thanked them as well. Hopefully, possibly I see it in July, but in just in case we don't, I want to thank everyone for being able to attend in person or on the telephone and being such exceptional commission members. I really appreciate that. You made my life a whole lot easier running this particular program, and I really thank you for that.
Cody.
Cody,
Yes.
Cody, I just want to thank you. It's been a long ride, but it's been fun. Jesse, we started at 8 o'clock that morning on orientation, so it made that day a whole lot longer.
Oh yeah, I forgot about that. Orientation.
I had to have the orientation, and I get there and I'm sitting. Oh no, what's this? But it's a bit. Cody, I just want to thank you and your staff.
Well, I
Beth,
appreciate that, David.
I'm
Yes,
gonna bring up
Beth,
Beth's name.
yeah.
Y'all are just done such a tremendous job over these years. So whatever be will be. But thank you very much and your staff.
And I appreciate you going up to the hill with us that time. And poor David was sitting next to me. He was just sweating bullets. Just knew they were going to ask him questions.
Amen.
They
All.
We
they
all
sat
feel
there
that
and
way.
they sat there and grilled one of the other senators, grilled one of the other boards, and really chastised him. I said, "Oh boy," he mentioned something terse about us earlier, and I thought when it came to be our time, we were going to get chewed up. And he says, "Well, y'all done a great job." What?
That was good.
Yes.
So we really appreciate that. Thank you.
Cody, this
Cody.
is Walt Valentine. I apologize. I don't know what's wrong with my computer, but the video is not working today. It was working Tuesday, but it's not working today. So I apologize.
Is that going to affect our board member meeting? Our formal hearing, Jesse? Does he?
It shouldn't, since we have a
Okay.
quorum already, and I can
All right.
clarify with the judge.
Judge, that we're having difficulty.
I'll close this out and try to redo it and get online.
And we'll have
Cody,
our formal.
if I'm not mistaken, we were talking about this bill. If the governor doesn't veto it, if he doesn't sign it, it automatically becomes law within like 10 days or 15 days. If he just doesn't do anything, it's going to become a law.
Right.
I think. Is that right?
I
Jesse?
believe that's how that works. I can't remember the time frame, but I think 10 days sounds right.
Okay. So I enjoyed it, Cody. So
Oh, I appreciate it, Doug. Thank you.
Excuse me,
Uh-huh.
Executive Director Vest. This
Yes.
is Lance Baker. I'm the city attorney for the city of Clarksville, Tennessee.
Yes, sir.
And this is in regards to APD case number 12.32-204632A. A number of our city employees were subpoenaed for a hearing today based on a complaint that William Welty Captain Welty with our loss prevention officers had filed with the commission, and Mr. Reese Smith subpoenaed several of our employees today for what we thought for an apparent hearing today.
Yes, sir. There's a hearing scheduled today. It'll take place after the commission's meeting. When we spoke with the judge and Mr. Smith a couple days ago, we did indicate that it's likely the actual hearing start time, because it starts after the commission meeting, would be at about 10 or 10:30. So we did say likely it would be 10:30, and I believe that Mr. Smith was going to provide those video links to you all. I guess are you all on one camera? Is that right?
Yes, all of the subpoenaed employees are present in this room
Okay.
and are available to testify.
Okay, and I think, because we had discussed that this would take place after the commission's meeting. So I believe the commission's meeting is about to actually wrap up here. I see
Okay.
Judge Merle had just joined back as well, and it looks like
Okay.
Reese Smith has joined as well. I think we may be missing one or two people still, but we can address that. We may be able to start a little bit early. I know I have a witness, and if he needs to join a few minutes early, I can have him do that if that's helpful.
Well, okay. Well, I think that we're about to wrap up this meeting for the Private Investigation Polygraph Commission for today.
Do I hear a motion to adjourn?
Yes, sir, you do. Commissioner Brown, let's make some motion to adjourn.
Bain,
Doug Shank,
second.
second.
Brown made and Bain seconded.
All right. We have a motion to adjourn. A motion was made by Brown, seconded by Mr. Bain. Stuart Bain,
Aye.
David Brown,
Aye.
Robin Johnston,
Aye.
Alan Russo,
Aye.
Doug Shanks,
Aye.
Walt Valentine,
Aye.
Kendall Barham,
Aye.
Charlie Bradley.
Aye.
The ayes have it, and we are adjourned. Thank you. Well, that was my last time to do that, I think, if it gets signed. I don't want to get emotional here. Just move on.
I'm going to close out, Cody, and try to invent this thing.
Okay, do we want to just maybe, everybody needs to stay on if they can. Maybe we just need to take just a couple minute break here. Let everybody,
Yes.
because we want to go
Stuart's
straight
just going to
into the
stay
formal.
on.
All right, we'd like everybody just to stay on if you would. You might want to get off audio, video, or whatever, but we need to be back in just a couple of minutes, right, Jesse?
That's correct. And that's what I'm saying. Judge Merle, I believe you're there, and Mr. Smith, since
Yes.
might be there as well. The commission meeting did just end. If we could just take a brief 5-minute recess or break before starting the hearing, so that way any commission members can just take a quick break if they need to. I think that would be helpful. I know when we had discussed at our pre-hearing conference, we discussed that this hearing would likely take place at 10:30 a.m. So I think it looks like we might have everyone here, so we may be able to start early. But Judge Merle, if you're okay with that, and Mr. Smith, if you're okay with that, just since our commission members have been on since 9 a.m., just to let them get a quick break.
I think the break sounds appropriate.
All right, thank you.
Hear me?
Yes.
We-
Yes,
we
I can.
All right, we can see you now. Thank you so much for addressing that.
You're welcome.
Who'll be serving as chair for the commission today?
Yes, I will. Walt Valentine.
Mr. Valentine, you'll be the chair?
Yes.
All right, are we ready to begin? Mr. Gentry?
Yes, Your Honor. I believe all of our commission members are back, and I believe, well, Mr. Rousseau, his video is not there, but I believe we should be ready in a moment. And I believe I see Mr. Smith.
Yes, Mr. Smith, are you also ready?
Yes, sir.
Well,
All right,
Jesse,
Mr.
what,
Valentine, if you will apprise me when the board members are present, we'll begin.
Okay.
Jesse, can you hear me? Do we have the court reporter?
I have not seen her join yet either. As I know we are recorded. I will.
Laura, can you make sure you record this?
Yes, ma'am, it is recording.
Okay.
I
She's
will.
the court reporter.
Mr. Gentry communicating with the court reporter.
Stuart, are you there?
I'm gonna message her now, Judge Merle.
Present and accounted
All right.
for there, Walt.
Okay, thank you. Judge Merle, the Private Investigation Board is present.
All right, sir. That includes one. So have you, were you successful, Mr. Gentry, in contacting the court reporter?
Give me one moment. I don't know if I have her phone number. I did just send her a message, an email message. I know we've gone without court reporters for some of these hearings since we've had these recorded. I'll give her a call here.
Laura did say that it was being recorded.
Right, and as I did just see, I just saw her phone number, so I'll give her a call.
Mr. Smith, I will apologize. I referred to you earlier as Mr. Reese. I had just gotten through with an order for somebody
You
whose
okay?
last name was Reese. Now you're here with a first name Reese. I'm easily confused on things like that, apparently.
You all right, Your Honor? No.
All right, our court reporter just asked for a couple moments to join the call. In the meantime, I would say, Judge Merle, I know that often with these commission meetings and board meetings, we do give the notice of hearing and charges to the board members and commission members at the start of the hearing. Just since our court reporter is about to join, would you like to have me email that to them now, or would you wait until the court reporter joins?
You can do it now if you want. It's going to be one of the things I'll highlight in the opening when we're ready to begin.
Okay, because I thought that may be beneficial, so that way I know when we start, we normally send that to them. I know a few judges have had me do opening after we already send it, so I guess I can go ahead. I'll send the notice of hearing charges to the board members, or Carol can, or sorry, is Carol in here? Carol, can you send that to Shauna to send the commission members so they can review the notice of hearing charges? And then when the court reporter joins us, we'll be able to start at that point.
Will do.
Thank you, Carol.
And before we begin formally, I will apologize in advance to the commission if I refer to you as board. Most of the hearings I do are before groups that are nominated as boards of nursing or
Come turn it up, please.
different things. And this is the first time that I've had the privilege of conducting a hearing with this commission. So I've tried to eliminate the word board from all of my documents, but we'll see how well that goes.
No problem.
Don't worry about that.
Well, I know I do the same thing, Judge Merle, and I represent this board as well as, or sorry, this commission and the Alarm System Contractors Board. So every once in a while, when I'm speaking with Director Vest, our executive director for the two different programs, I'll accidentally use them interchangeably. So that is, it happens.
As a matter of quipping, I think occasionally in some meetings, we have been board commission.
ARED.
That is your interpretation.
All right, commission members, you should get a copy of that notice of hearing and charges to review before we start. Jenny Ailes, our court reporter, has joined us, so she may need a moment to set up before we can officially start on her record. But if you all would review that, it's the same notice of hearing and charges that was filed with the Administrative Procedures Division and served on Mr. Smith.
And I am ready whenever you're ready.
All right, Ms. Ailes, this is Richard Merle. I'll be the administrative judge today. All right. Well, today is April 22nd, 2021. We're present via WebEx for a hearing before the Tennessee Private Investigation and Polygraph Commission. The commission will consider the case of Reese Smith doing business as Justice Now Press Civil Rights, which is the matter denominated as docket number 12.32-204632A. Mr. Smith is present. Mr. Smith, will you introduce yourself to the commission, please?
Yeah, my name is Reese L. Smith Jr. I'm the founder of Justice Now Press. When I first started this business in 1984, it was called Falsely Accused. I started the business after I was falsely accused in 1980 for robbery and rape. And I served since. Yeah. And you'll have an opportunity to make an opening statement. This is just to introduce yourself so they'll know who you are on the screen. Mr. Gentry, will you introduce yourself, state your appearance, please?
Yes, my name is Jesse Gentry, and I'm the Associate General Counsel for the state of Tennessee, and I represent the Department of Commerce and Insurance and the Regulatory Boards Division.
You have a client representative or party representative?
My party representative would be Cody Vest, our Executive Director for the Commission, and she is on the call as well.
All right. Are there witnesses that we need to address? Anyone calling for the rule of sequestration?
I am not. Well, I am not going to request that. However, I would like to address, I would say I had filed my witness and exhibit list. In my witness and exhibit list, it was actually, I filed it twice. I filed it before the first hearing, before it was continued, and then I refiled as a courtesy to make sure it was refiled for this hearing date. And my witness and exhibit list indicated Kevin Richards, Cody Vest, Mr. Smith, and any witness of Mr. Smith. My understanding is Mr. Smith has subpoenaed individuals. I know at our pre-hearing conference earlier this week, Mr. Smith had mentioned having witnesses. I believe, and it's indicated on the screen, William Welty is here. I'm not sure how many, because Mr. Smith never filed a witness exhibit list, so I'm not sure how many witnesses he has. I don't know how many witnesses he subpoenaed. And I do believe that these witnesses, I mean, it's indicated as Mr. Welty, but I know the city of Clarksville attorney is there, and I believe there might be 2 or 3 witnesses. I'm not sure how many people are on that specific call.
Judge, this is Lance Baker. I am the city attorney for the city of Clarksville. We have several people here who were our witnesses to the incidents that occurred, and each of them were subpoenaed by Mr. Smith. And that would be Lael Bowen, Lael is Lael. Bowen, Bowen. He is a loss prevention officer with the city of Clarksville. Captain William Welty. Welty is Welty. He's the captain, loss prevention officer with the city of Clarksville. And we have Unita McLeod. Unita is Uneeda. McLeod is MCCLOUD. And we have Brandy Jarrell, BrandyJarrell. And then we also have the department head for the gas and water department, although he was not subpoenaed, and that would be Mark Riggins, Riggins. And Mark is MARK.
Thank you. Mr. Smith, of those persons, are there any that you intend to call as witnesses on your behalf?
All of them.
Yeah, all right, sir. Mr. Gentry, are there any of those witnesses that you'll be presenting in your case in chief?
Well, Your Honor, so that's part of the issue is I didn't include any of them as witnesses because I didn't find statements that or their testimony necessarily relevant to the issues at hand. I know Mr. Welty being the complainant or the designated complainant for the complaint that was filed. If he testifies in terms of the complaint that he made, the interactions he had with Mr. Smith, I don't have a problem with that. I don't know these other individuals though. They weren't included on a witness and exhibit list. I was not informed of who they are, so I would respectfully request that all of them, other than Mr. Welty, because he was the one who made the complaint to our department, that the rest of them be excluded from testifying.
Mr. Smith, do you have any?
I'm objecting to that because number one, Mr. Gentry filed this whole complaint on the grounds of what his investigator done, who he spoke with and who he talked to. So no, I object to that because Mr. Gentry, if you didn't want to use them, then they shouldn't have been used by your private investigator to get a statement to insinuate that I was doing something wrong when I wasn't. So no, I object to that, Mr. Gentry, because this is something you started, so deal with it. The truth is gonna come out. This never should have even been filed by you.
Mr. Gentry, I will reserve ruling on that if these happen to be presented in terms of rebuttal. It may be appropriate. The subpoenas were filed. I know that's not a witness and exhibit list, but it certainly, gave notice of an intention to have witnesses present. We'll have to see as the case progresses whether there would be other objections in terms of relevancy or depending on the issues that as they develop. While I'm fairly good at my job, I'm not very good at mind reading, so I don't know exactly what the case is going to develop. I've read all the material, but we'll see as it goes along. I'll reserve ruling though on your objection or exclusion of any witness.
Well, and just one last thing I would like to say, Your Honor, is I did not receive copies of these subpoenas. The Administrative Procedures Division, I don't believe, sends those to us that they were filed. So I actually did not receive information in terms of those subpoenas being filed for each of those individuals by Mr. Smith. And then we did not necessarily have notice that. I understand they were filed with the Administrative Procedures Division, but those actually were not ever sent to us. So I would like to make sure that was clear.
I know that they were mentioned in our pre-hearing conference. And of course, everything that is filed with the Administrative Procedures Division is public record. So while it wasn't directed to you, you had access. I'll continue. I'll introduce myself. My name is Richard Merle. I'm the Administrative Judge assigned by the Secretary of State in the Administrative Procedures Division to preside over this hearing, sitting with the Commission. I'll make rulings regarding the order of proceedings, the admissibility of evidence, and any procedural questions related to the law pursuant to the authority that I'm granted by the Tennessee Administrative Procedures Act. In other words, it's my duty to conduct the hearing, regulate the course of the hearing, rule on evidentiary and procedural legal issues involved in the hearing. However, I will not participate in finding the fact, conclusions of law, or the ultimate decision of this commission. Those decisions rather will be made by the commission members. At this time, Mr. Valentine, I'd ask you to introduce yourself and then the other commission members and tell me if there is a quorum present. Also, the commission members need to take notice of the persons who are active in this case. If there are issues that you need to declare on the record in terms of prior contact with persons that might indicate a conflict of interest, we'll need to hear about that. So, Mr. Valentine?
Yes, sir. I'm Walt Valentine, a private investigator, a retired FBI agent, and I'm chairman of the Private Investigation and Polygraph Commission. David Brown is the vice chairman. Stuart Bain is a member. Robin Johnston, Alan Russo, Doug Shanks, Kendall Barham, and Charles Bradley are the other members, and they're all present, so we do have a quorum, Your Honor. Do any of the commission members have a conflict of interest in hearing this case?
We'll recognize Mr. Russo.
Mr. Russo, do you have a conflict?
I do not have a conflict, but I don't know how to answer that. I have not received the email with any information, so I do not know who all the parties are.
Did you receive the notice to hearing and charges, Mr. Russo? I believe Shauna had sent the a few minutes ago.
I have not received it. I will check my spam folder. Has anybody else received?
Yes, I did receive it.
Stuart Bain has also.
Alan, I can resend it to you right now.
Thank you.
All right, so the only parties to this case are Mr. Smith, whom you've heard from, and the regulatory board's department, their investigation. So adjunct to the commission, the investigative arm of the regulatory boards will be presented. Does that help you, Mr. Russo?
I just received the email. Yes, sir, John.
All right. Then hearing no statements of any conflicts that need to be presented on the record, I'll ask counsel if there are any preliminary motions or matters that need to be discussed. We've already covered a couple.
No, Your Honor. I don't have any. I'm not sure if Mr. Smith does.
Mr. Smith?
No, sir.
All right. I'll continue. The members of the commission are reminded that during the time of this hearing, no discussion concerning the case may take place between the commission members, the judge, the witnesses, the respondent, the attorneys, or other commission members, commission staff, or any other persons outside of the hearing itself. During the hearing, the commission sits like a jury and must only consider evidence admitted during the hearing to reach its decision. The Tennessee Sunshine Law or Open Meetings Act requires that all commissioners' discussions and deliberations be in public and before all the parties that are present at the hearing. Failure to comply with the Tennessee Sunshine Law could result in the commission's action being reversed or remanded if it's appealed to Chancery Court. During this hearing or any breaks that we take, you may not use any electronic device or media, any type of smartphone, tablet, iPad, computer, internet service, texting, instant message service, chat room, blog, or whatever else might exist to communicate any information to anyone or receive information from anyone or to conduct any research about this case. You should not draw any conclusions until all of the proof has been submitted. You should listen openly to all the proof, regardless of which side submits it. Each of you has received the notice of hearing and charges. It circumscribes the issues that we'll be considering today. The technical record consists of documents filed with the Administrative Procedures Division. Those documents include the notice of hearing and charges, which was filed December 10, 2020. There was an order setting a pre-hearing conference. Following the pre-hearing conference, there was a scheduling order. Then, as Mr. Gentry mentioned, he filed a witness and exhibit list January 4th of 2021. The matter was continued, and that order of continuance was entered on January the 13th. On March the 19th, Mr. Gentry filed his witness and exhibit list, and following a pre-hearing conference earlier this week, Mr. Smith filed a notice of served subpoenas on April the 19th. Mr. Gentry, are there any other items you think should be included in the technical record?
No, Your Honor.
Mr. Smith, any other items you think should be included in the technical record?
No, Your Honor.
All right. These documents will be entered then as the technical record in this case. Should you need to review them during the proceedings, I'll make sure that they are delivered to you. I remind the attorneys that the documents in the technical record and you, Mr. Smith, are not considered evidence unless they are admitted into evidence during the hearing. The board members are, I did it there, the members of the commission. The law requires you to disclose on that record any outside knowledge. We've gone through that, and there were no disclosures. So before beginning the trial, we'll give you some instructions to help you understand how the case will proceed and what your duties are in your conduct of this hearing. When I've completed the instructions, Mr. Gentry and Mr. Smith will make their opening statements. The statements will be brief outlines of what the attorneys expect and Mr. Smith expects to be the evidence presented. After the opening statements is when you'll hear evidence. The opening statements themselves are not evidence and hence are just brief outlines. The evidence will generally consist of any numbered exhibits that are admitted and then the testimony of witnesses. The state has the burden of proof. The state will also present its evidence first. Mr. Smith is the respondent, and he'll be given an opportunity to present evidence following the state's closure of their proof. Although the evidence is presented by asking witnesses questions, the questions themselves are not evidence. During the course of the hearing, there will be an opportunity for each one of you to ask each witness who testifies under oath questions. You need to use your opportunity to ask these questions to gain clarification of the facts that you think would assist you in reaching a decision in this case. However, you should reserve any expression of opinion you may have until that portion of the hearing that's set aside for the commission's deliberation after all of the proof is heard. During the hearing, objections may be made to evidence or trial procedures. I may sustain an objection to questions asked without permitting a witness to answer, or I may instruct you to disregard an answer that was given prior to my ruling on an objection. In you're deciding this case, you may not draw an inference from an unanswered question, and you may not consider testimony that you're instructed to disregard. Any argument about objections or motions usually requires the attorneys, or in this case, Mr. Smith's oral argument, to be made outside of the hearing of the commission. Information may be excluded because it is not legally admissible. Excluded information cannot be considered in reaching your decision. A ruling that is made on an objection or a motion will be solely based upon the law. You may not infer from any of my rulings that I hold any view or opinion for or against either party in this hearing. When all the evidence has been presented to you, the attorneys, Mr. Gentry and Mr. Smith, will make closing arguments. They will point out to you what they contend the evidence has shown and what inferences you should draw from that evidence, and how you should apply the law to reach conclusions of law. The state will make the first closing argument, followed by Mr. Smith. The statements made during closing arguments are not evidence. The attorney's statements are made to help you understand the evidence and the way they view the application of the law, and you should ignore any statement by counsel or Mr. Smith that is not supported by the evidence. The burden of proof, in this case I mentioned, is borne by the state. The state must meet its burden of proof by a preponderance of the evidence, which means that amount of evidence that causes you to conclude that an allegation is probably true. To prove an allegation by the preponderance of the evidence, a party must convince you that the allegation is more likely true than not true, or that the issue should be determined in favor rather than against that individual. If the evidence on a particular issue is equally balanced, that issue has not been proven by a preponderance of the evidence, and the party that has the burden of proving that issue has failed. You must limit your inquiry or your questions regarding violations of the statutes and rules to those violations that are alleged in the state's notice of charges in this case. If you believe that the respondent acts have violated a statute or rule that has not been alleged in the notice of charges, you may not inquire into or address those violations. Specifically, the commission must determine whether the acts proven by the state, by the evidence, to have been taken by the respondent, or admissions of acts taken by the respondent, constitute acts of an investigations company or private investigator subjecting the respondent to the requirements of Tennessee Code Annotated 62-26-204, and if so, whether under the totality of the circumstances, any discipline under TCA 62-26-217 is warranted, and if so, what that discipline should be. After closing arguments, I will instruct you on the rules of law that apply to this case. Your function as members of the commission is to determine what the facts are to apply the rules of law that I give you to those facts, to make conclusions of law in which you decide whether or not the respondent, in this case, Mr. Smith, has violated certain rules or laws that this commission oversees. And if such violations have occurred, what the proper discipline is or what the proper action is, if any, that should be taken against Mr. Smith. The commission will then need to state a policy reason for the decision that it makes. As the sole judges of the facts, the members of this commission must determine which of the witnesses' testimony you accept, what weight you will attach to the testimony that you accept, and what inferences you would draw from it. The law does not require you to accept all of the evidence. In deciding what evidence you will accept, you must make your own evaluation of the testimony given by each witness and determine the weight you will give that testimony. You must decide which testimony you believe and how important you think that witness's testimony is. You're not required to accept or reject everything a witness says. You're free to believe all, none, or part of a person's testimony. In deciding which testimony you believe, you may rely on your own common sense and your experience. So I've heard no request for sequestration of witnesses. And if there is nothing else, we're ready then to begin the case. Anything from the commission, Mr. Valentine?
No, sir, we're ready.
All right. It is 10:39. My intention would be to offer comfort breaks after about 2 hours, but anytime you need to bring to my attention a need for some break, we'll take that. And the commission can decide when you would want to break, like for lunch, or if you want to press forward. And I will be mindful of any need that the commission has to close the hearing at a particular time. You just need to make that, bring that to my attention. Otherwise, we're ready to begin. We'll start with the opening statements from first Mr. Gentry and then Mr. Smith. Then we'll get into the evidence to be presented.
All right, thank you.
Gentry?
Thank you. We're here today to see if there was a violation of Title 62, Chapter 26, which is the Private Investigations Licensing Act. Just as a little way of background, which you'll see from the evidence, a complaint was filed that ended up leading to an investigation in terms of Mr. Smith and his business. At the time the complaint initially came in, there was just some confusion as to what his business did. I believe Mr. Welty is here as one of Mr. Smith's witnesses, and he'll be able to testify a little bit about that initial interaction he had with Mr. Smith. But our investigator, Kevin Richards, met with Mr. Smith and talked to him about, what it is that his business does, because it was uncovered that his business, Justice Now Press Civil Rights, maybe there was a concern that he was acting as a security guard or something else without a license. So the state, in its proper procedures to investigate licensing issues, investigated this case. Upon meeting with Mr. Smith, he had indicated that Justice Now Press Civil Rights, and I'm sure he'll get into this and he can tell you more about the background of it, but they've been around for several years. In the work that they do, they meet with individuals who have either been convicted of a crime or, I guess, have charges against them. Maybe they haven't been convicted yet, and he can clarify that, because I believe in his statement he said He had helped prevent some people from being convicted of crimes. So he is meeting with individuals who have criminal charges or convictions. He reviews documents, and he also interviews witnesses as part of those criminal cases. When we look at what the definition of a private investigator, are they investigating the crimes or wrongs done, threatened against the United States or any state or territory of the United States? If you're investigating someone's background or interviewing witnesses as part of a criminal case, you are investigating a crime or wrongdoing. Under that definition also, we look at, are you looking at securing evidence to be used before any court? Well, if you're interviewing witnesses to help people have their convictions overturned, then yes, you are helping secure evidence to be used in front of a court. And he was clear that he has helped several individuals who were wrongly convicted of crimes have their crimes or their convictions overturned or be released. And I think that is great work that needs to be done. We need private investigators doing this type of work. However, we also have licensing requirements that require certain requirements. We require, as of right now, we require private investigators to be licensed. We require their companies to be licensed. I believe Mr. Smith himself is the one doing this work. He indicated he's done work in Clarksville, Springfield, and Davidson County. So he's working in the state of Tennessee. He himself is doing this work as a private investigator, collecting this information. And he did tell our investigator this and provide this in an affidavit as well. And then his company, which is also duly formed in the state of Tennessee, Justice Now Press Civil Rights, that is formed in the state of Tennessee, and this does this business. So there's actually two violations. One, Mr. Smith acting personally as a private investigator without a license, and then his company acting without a license. Both of those would be required to be licensed under Tennessee Code Annotated 62-26-204, and violations of those subject to him to a penalty of up to $2,000 per penalty. Mr. Smith, I believe from his own testimony, it is in his affidavit as well, but I believe he will testify as well that his business model, what he does is he gets a power of attorney from these families and tries to act on their behalf under that power of attorney. There's not an exemption in our statute that allows another individual to get a power of attorney to investigate crimes on their behalf. If Mr. Smith was investigating crimes alleged against him, that would be one thing. But if he's getting a power of attorney for someone else to investigate that, he is therefore acting as a private investigator to investigate these crimes. Now, I do think it's an interesting distinction because he's trying to say he's acting on their behalf.
Ms. Ailes, are you still with us?
I'm here, Your Honor.
All right. It's one of these little yellow triangles on your square on my screen, so I couldn't tell if you were connected. Go ahead, Mr. Murphy.
Thank you. So Mr. Smith does, use his power of attorney to help work on behalf of these people, and that helps him get these court records, is my understanding. And that's what a power of attorney would allow him to do in these situations. But again, there's not an exemption in the statute that would allow someone to do this. We would probably have almost no private investigators if everyone just needed a power of attorney to go act as a private investigator on someone's behalf. We have a licensing authority in place that requires licensure to make sure that we have duly licensed individuals performing these services because they're important services. There's requirements, to make sure that citizens are protected by, misconduct. We don't have any allegations that Mr. Smith necessarily engaged in misconduct. We are here just on this issue of whether or not he needed a license. But that's the reason why we have these licensing requirements in the first place. So from his affidavit, he has stated some numbers of individuals that he has worked with. He has stated the type of work that he does. And I believe from the proof that will be presented today, and he can, outline all of that as well. I think that he's probably the best person to tell you what his business does. And he has told us that in his affidavit as well. But he's the best person to tell us what this business actually does and can explain to you. And I think after all the evidence is presented, I think that, Mr. Smith should consider applying for a license as himself anyway, no matter what the outcome is today, because I think that what he is doing does require a license. There's reasons why we have this licensing authority in place, and he's acting as an individual and a company without licensure. Thank you.
All right, Mr. Smith, you want to make your opening statement, and bear in mind that this isn't the evidence part. This is just an outline. All right?
Yes, sir. Yes, sir. My name is Reese L. Smith Jr. I'm the founder of Justice Now Press. But before it was changed to Justice Now Press, it was called Falsely Accused. In 1980, I was accused of robbery and rape, something I wasn't guilty of. And after 3 years, I got my case back presented in court and got to prove that I wasn't guilty. I was found not guilty of robbery and the rape. So after being released, then I moved to Tampa, Florida, and started Falsely Accused. And what I was doing was in church. I wasn't a minister at that time. I was just in church working, helping out. And the members had a couple of problems with the members in the church who was arrested, and they didn't understand their case. And they had lawyers, but the lawyers really didn't have the money to pay for investigators to come in and review the case. So what I'd done, I would sit down with the family, and what they would do was give me the power of attorney to go to the courthouse to get any records, any information that I need, any statements, police reports, and any officers that was involved with the case, I would go and pull their file, because a lot of times we don't know about these cops. Just because you're calling them testify don't mean that they're good people, because they do have bad records if they've been suspended, reprimanded. So what I do is I go pull every cop record that's involved with the case. And every time the court present 12, 13 cops, I have their files on the jury, on the table with the attorney. Because if that cop testify, his life becomes open to the public. Because that's knowledge where anybody can go get their records. That's public records. You can't deny me from requesting that. So when they're showing 11, 12, 13 cops, every case that I have helped, they only went down to 1 or 2 cops, because the rest of them been suspended, reprimanded, and the state didn't want to be looking bad when they already look worse as it is. Because here they are proving a case to say this person is guilty, but if you got a cop being reprimanded, suspended, and the jury realize he's no credible than the people of the defendant. So that is how I do my business, to help these people, because I was wrongly convicted on something I wasn't guilty of. So through my experience of learning, reading, studying, and getting my case overturned to present that what happened never happened because I wasn't guilty. I got out of prison. I was a free man. I made a vow that as long as I got breath in my body, that I would help people who don't know the law, understand the law, to sit down, teach them how to read, understand, how to do research, how to look up the Supreme Court, how to look up the state court on cases, the reason why it was overturned and this person got to go home, or the court finding people, the state submitted evidence that was not true in the beginning. So after all that, I've been doing this over 30-some years. I have never been accused, arrested, or anything. I only got arrested once when I was in Jackson, Tennessee, working a rape case. And I proved that the guy didn't rape his stepdaughter. I sat in jail for 5 months when they realized that they would hold me because they didn't want to present the evidence. So when they found out they didn't have the evidence, because the sister who hired me gave me the power of attorney to do the work, and the 3 days I was out there collecting what she asked me, she was with me. And when they found out that she was with me, I wasn't acting on my own authority, I was acting under hers, because she was with me. I was teaching her how to go to the courthouse, how to get the information, request the information, how to prepare, how to put the statements and everything together. So there's nothing that I'm doing wrong or anything that I'm doing that's making anybody think, because if I was doing anything wrong, my PO, I went to see her I'm on probation. And I went to see her one day. I was in uniform. She called the Clarksville police for impersonation. The cop came out, spent the hour, reviewed me, reviewed my license, reviewed my business card, looked at me, he checked me, and he came back and told my PO he's not doing anything wrong. He has a business license, he's helping people, and he's not presenting himself as anything but an agent. And since he's not breaking any law, I'm gonna let him go, and I refuse to arrest him because he's not doing anything wrong. That cop stood there, looked at me, looked at my PO, said, I'm gonna tell you one thing. He looked good in his uniform. He's representing his business. So, ma'am, I have no further business with Mr. Smith. Have a good day. Shook my hand, and I went back in, and my PO said, well, I have nothing else to say to you because you're not breaking no law. I said, no, I'm not breaking the law. And I've been doing this ever since. So whenever I get calls, I contact my PO, let them know I have to go here, go there. And they say, we'll give you traveling papers, Mr. Smith, go ahead. And that's what I do. So if I was breaking the law, doing anything wrong, my PO would not give me the rights and the privilege.
Your Honor, I'm going to move to strike this. Your Honor, I got to move to strike this. I would say this is a lot of hearsay.
Well, it may be hearsay. It's not evidence. It's in the opening statement. Mr. Smith, your opening statement is supposed to be a brief outline of what you expect to prove.
Well, then, okay, well, then that's going to be it for my opening statement. I'm giving a background from what started to now. So I am finished my opening statement. I gave enough background on who I am and what I do.
Thank you. Mr. Gentry, you want to call your first witness, please?
Well, Your Honor, I think the first witness to be most efficient would likely be Mr. Smith, since my other witnesses are going to testify to the statements that he made to them. So I think it would be most efficient to start with Mr. Smith and then have Kevin Richards after that.
All right, Mr. Smith?
No.
Raise your right hand, please. Mr. Smith, raise your right hand, please.
Yeah.
You've been called to testify, and the testimony you give today, do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you.
All right, thank you. And Mr. Smith, can you just state your name for the record one more time?
Reese L. Smith, Jr.
All right, and what is your role with Justice Now? Is it Justice Now Press or Justice Now Press Civil Rights?
Justice Now Press Civil Rights, because I am a civil rights activist for the falsely accused and defendants.
Yes, sir. And what is your role with Justice Now Press Civil Rights?
I'm the owner.
Okay. How long has Justice Now Press Civil Rights been in operation in the state of Tennessee?
Since 2000.
Okay. And have you been the owner of it since 2000?
I've been owner of it since 1984, sir.
Well, that was okay. In Tennessee, you've been the owner the whole time since 2000, correct?
Yes, sir. Yes,
All right,
sir.
thank you. And what type of business does Justice Now Press Civil Rights engage in?
We engage in people who are arrested and feel like that they're in jail and what's supposed to be presented, gonna find out the facts are not being presented as they should. So when they're sitting in jail, I have a talk show that I talk to people, and on Facebook as well. And I give them backgrounds when they contact me, ask me about this situation, the case. And I say, well, let me go do some research. And then whatever I have, I'm gonna give you a copy so we both can read the same thing, because I'm not giving you my expertise, I'm giving you my background of what I know and what I'm reading. So what I do, I go look up the Supreme Court guidelines and the state court guidelines. And I give them copies of what the Supreme Court ruled on certain cases, murder, robbery, rape, and the reason why they said this person was done wrong. And I also do research on state reason why the Supreme Court overturned their case and said what they did was wrong. So I sit down, and once I get the information, I give them their copy, I meet them, and we go sit down at Shoney's or wherever, and we started reading together on what they need to know for themselves, why the Supreme Court state that the state shouldn't have done this and what they done wrong and why the Supreme Court overturned it. So that's how I do my research. So by me, I give seminars as well. So people can know what they need to know for themselves, because attorneys, most of them are lazy and don't do what they need to get your case presented and facts to show truth. So I help them to let them know your lawyer works for you. You don't work for him. And whatever you decide you want to do with your case, you have every right to tell him what he needs to do and direction he needs to go.
Thank you. And let me go on.
ahead. No, go ahead. I'm done.
Okay. I just want to back up a little bit. So are you the only owner of Justice Now, or is there a partnership or other owners involved with this company?
No, I'm the only owner. My boss, who passed in 1996, after he died, he was a high profile attorney.
Okay.
He sent me to school. Oh, go ahead.
It just, so you're the only owner. I know you'd mentioned you have a podcast, you do seminars. How do these families find you? How do they find your information? Do you know?
On Facebook, they read my background, they read my stories on how I help families that I have helped, families who have been found not guilty, families who I have gotten out of prison. They read my stories and they realize, oh, so you know what to do with the court system. You know about the court system and you know how to help people. I said, yes, I do. Well, I have this situation problem. I said, well, let's just sit down and talk and let's see where you're going. Because in order for you to know where you're going, you got to know where you're coming from. And you got to understand what you're doing with your case. You can't just go in there and be dumbfounded. It's my job to bring knowledge to you so you understand.
So, Mr. Smith, when you're responding to the questions, you need to just answer the question that's asked. Okay?
Yes, sir.
So when these families, when these families contact you, do you sign a contract with them, or do you meet with the families? What do you do with these families?
So when they contact me, we'll meet somewhere, we'll sit down, we'll eat, and they explain to me the situation. And after they explain the situation, they would say, well, this officer, he did this and that's not what I told him, he lied. I said, okay, I'll go pull his record. Let's see what kind of cop he is. And then once I pull his record, if he's been reprimanded, suspended, I say, look, this is what this cop done. So in reality, when you go to court, you got him on trial now. So if he get up there and try to sound like he's credible and all, he's so inspirational, he's looking good now. But now once they open up his files, now we got a problem. Because the jury said, no, in their mind, well, if he's been suspended, reprimanded for inaccurate reporting. Yes, sir.
Mr. Smith, let me try to focus you. The question he asked was, do you sign contracts with these people that you meet? He's not asking about what
I was getting to that. I was getting to that.
So let's get to that.
Yeah, and I was telling them, yes, I do, because I meet with them, and after I explain to them, and they tell me their story, and I read, because they bring all the information to me, and I'll start reading. That's when I tell them, okay, you need this. A lot of people are afraid to go to the courthouse to get information because they don't want to be like they don't know how to receive or talk to people. So they be like, well, can you go get my files? Can you go get? I say, yeah, but you got to sign a power of attorney for me to go in there and receive your information, because they're not going to just release it to me. I got to have something that says I have the right to receive and retrieve whatever you ask me. And once they see that power of attorney, they give me what you asked for so I can come back, sit down and talk with them.
So when you sign that power of attorney, is there a contract with them for services that you're going to, or you or your company are going to provide for these individuals? Or do you just discuss orally? Well, do you have a written document with them that says Justice Now Press Civil Rights will do these things, or do you just orally discuss that and say, here's what I
have a contract, because your private investigator saw my contract. He saw everything that I use in my business. I had to lay it out on the table for him. And he saw everything that I use for my business. And he saw my contracts and everything. So he should have had a copy of that, or he should have took a picture of everything, because I have all that.
Okay, and with these copies or these contracts, what type of services are you providing for these individuals or their families?
Travel if I have to. If I gotta go out of town, if I gotta go somewhere else. Let's say they have a case in, like I got one in Chattanooga. Let's say there's a case in Chattanooga, and my client, he's in prison, all right? He's in prison, but he don't have no way of getting anything. So he calls fiance, she calls meet with me, and she said, well, he needs this. I said, okay, he needs all this, but he's in prison, so I can't get it unless he give me the power of attorney to go pick it up. And in that power of attorney, he states everything he wants me to do. Pick up his chart, pick up his arrest, pick up his evidence tree, pick up his witness list. Everything he requests is on that power of attorney. So when I went to Chattanooga and presented that to the clerk, everything he had on there, I got.
Okay.
That way, I was able to, go ahead.
So do you testify in court then for these individuals in terms of these investigations?
If I have to, I let them know how I got the information, how I retrieved it, and what I done, and what they asked me.
Okay.
Sometimes I have to go to the prisons and talk to them.
And when you're talking to these individuals and providing them this documentation, we're not talking about just any other business records. You're not picking up bills for them. What are you specifically providing? What types of documentation are you providing for them?
Anything from the court. If they got, let's say they need their transcript. Well, we don't have a transcript. I say, okay, I find out who the court reporter is and find how much it's gonna cost the family. And that's what the family does. Once I get that, and they say, well, it's gonna cost $300 for the transcript, then I go back to the family, say, it's gonna cost you $300. They say, okay, here's the money. Can you go pick it up? I go back, let them know, here's the $300. When you gonna have this transcript ready? Give me a call, and when they get it ready, they call me and I go pick it up. And then I take the transcript to my constituents and let them have it. Here you go. There's your transcript. That way, when they get a lawyer, he already has what he needs. He ain't got to do no run around. That's cutting out a whole lot of run around that he has to worry about when he don't. He got everything.
And do you interview any witnesses? Do you do any, maybe not a deposition, but do you sit down and take notes and interview individuals?
Yes, sir. Every time I have my video with me, because whatever they tell me, they better testify to the truth then, because I'm always gonna have my video say, well, that's not what you said with me, because we talked. And I have never caught any of my witnesses getting up there. I have had them turn their statements around what a cop said because they know what he told the cop. A lot of them been threatened through the state or the police officer. They didn't say this was gonna happen to them. So when I present the video to the lawyer, I said, well, you need to look at this video. This is what they told me. And when they get on that stand, everything comes out what they tell the truth. They say, no, that ain't what I told Mr. Smith. I know what I told him because he recorded it. And that's when they sit up there and tell the truth.
Who are these individuals that you're interviewing? Are they police officers? Are they witnesses? Who are they?
Yeah, they're police officers, witnesses that was involved, like this murder case I'm on that I've been assigned to. He's been in prison since 1994. And things that were submitted, we found out wasn't submitted. Evidence that was put in there, we found out was put in by the state and his own lawyer. After that, he's just been given a new hearing. After 30-some years, he's been given a new hearing now, because the doctor who was on the case, the medical examiner who was on the case, falsified and lied And couldn't find out there was never no box cutter used in this murder. So all this is finally coming out to where the gun that was used, the woman owned the gun. They got into a scuffle. He took the gun away from her and shot her.
Okay.
So
Who found this information to have this case overturned? Who, or to have a new trial? Who found this information?
I found it through my reading.
Okay. When you say you're reading, so what were you reading?
I got a copy of his whole complete file.
Okay.
And in the file, the examiner stated some things that they didn't know. And then come to find out, the cop gave a statement that wasn't true. And when I started reviewing his old chart, I went back and started doing some research, kind of find out, whoa, this examiner was suspended and fired for lying and obstructing evidence to the case. So he's no longer around. He died. So he's dead.
So you read this information in the report. Were you working for the family at that point?
Yes, sir.
You weren't working for the attorney. You were working for the family. Is that
No,
correct?
sir. No, sir. No, sir.
Okay.
I work for the family.
And what did you do with this information when you found it? So
I
did you
turned it over
provide
to
it to
him.
the family, or okay, you provide to them?
Yes, sir. I turned it over to him.
And then did he use that in the court case? Do you know?
Yes, he did, sir.
Okay. And just, I know we talked. You started the business in 2000. How many cases do you typically work?
I started
I'm
the
sorry.
business in 1984.
That's correct. I'm sorry, I misspoke. You started the business in Tennessee in 2000, correct?
Yes, sir.
How many cases do you typically have per year? How many cases have you worked since the start of 2021?
Oh, no, how much? Ooh. Well over 400 or 500.
400 or 500 this year alone?
No, not this year.
Oh, okay.
No,
That's
not this year. Yeah,
Sorry,
I'm talking
maybe that
about-
was confusing. You're saying since start of 2000, 400 or 500.
Yes, sir. Yes, sir.
Okay. Okay. And when you're working these cases for these families, are you being compensated for your services?
No, no. The only thing they do is just take care of my expenses.
Okay.
If I had
When
to
you-
go, like when I had to go to Chattanooga, I was gone for 2 days. They paid for my hotel, my gas, and my food, and my rental car.
Okay.
And then I came home. They pay all my expenses. That's it, because that way they don't have to make those trips. I'll get on the road and go do what need to be done and get it over with, take my time and get back home.
Okay. And I know you said for your hotel, I guess, they reimburse you for your hotel. What about for any time testifying or time reviewing cases? Are you reimbursed for any of that time?
No, sir. No, sir, because I love reading and looking at the cases and reviewing them.
Okay. And when you said, I know you had said in your opening statement that you have, or I guess your probation officer had looked at your license. What type of a license is that?
It's a business license.
Okay. So you don't have any type of license from the state of Tennessee as a private investigator or a private investigation company. Is that correct?
No, I don't operate as a private investigator, sir. I act as an agent to help the families. I don't do any private investigation work. Private investigation work is where you get on and you have to go find evidence, find people, find witnesses. I don't do that. I go on what I have, and whatever names is in the paperwork, that's what I go on. Any cops, I go pull their records. Any witnesses, I go back and see if they're around, or if I can speak with them, ask them what's different now that could have been different from that time. And they'll tell me, well, they threatened me if I didn't say this. I said, wait a minute, who threatened you? And I'll get it all on video so they'll know you threatened them and scared them. So we don't know if they told the truth or they lied, and then they admit I lied. I just told them they wanted to hear. That's when a lot of things get kind of touchy.
Just one moment, I'm just checking. I just want to make sure I've covered everything I don't want to misstate you, and I don't want to say anything you haven't, or ask you anything you've already testified to. So are there any other services that you provide other than, so I think you said you research documents, you collect documents, you interview some witnesses, any other work that you provide for these families?
Oh yeah, I am a elder at the church, so I provide ministry to them, provide spiritual support, pray with them, talk with them, and just I give them what I think they need to hear. A lot of them don't have strength to go on, so I tell them, you need to pray, or we'll pray together, or I pray for them. And I stand by their side while they're going through what they're going through, because I give them strength, and I let them know, you have no reason to be afraid if you tell them the truth. Now, if you're lying, that's another story.
Right.
I can't do nothing if you're lying.
No, that's great. You did mention that you have testified in court as to some of the documents that you've collected.
Yes, sir.
When you're testifying in court, I imagine, are you testifying on behalf of these family members? Are they there in court also? Are you their witness?
Yes. I've also testified in front of the grand jury several times, and the grand jury have came back and found no true bill.
Okay.
Thank the Lord that they do that.
Well, it's rare with the grand jury to find no true bill, but when you're testifying, is it specifically as to the into the work that you're doing for these families, or it's not any other type of testimony? It's not you as a witness to any other activity. It's specifically about the work that you're doing for these family members. Is that correct?
It's just about the work I'm doing, what I asked, what I questioned the witness about, what he told me. And then if they need to, I'll pull my video and let them know this is what happened, because I'm not going to give you anything out of my mouth that's not the truth.
Right. And then do you provide any type of written report, or
yes, sir.
You provide that to the family, like a written summary of the work that you've done?
Yeah, when they give me statements, I want it in writing. I want it notarized, because that's going to the judge, because it's going to the state as well. Because once you get on that stand, I pray to good Lord you don't change anything in there, because you're in trouble.
All right. And then I think you'd mentioned this a little bit, but you're still currently in business. You're still working cases right now. Is that correct?
Yes, sir.
Okay. How many cases are you working right now?
3.
3. And those are all in the state of Tennessee?
Yes, sir.
Right. And those are related to criminal cases for those individuals. Is that correct?
Yes, sir.
Okay. And what type of work? Just, I think you said one of those is that murder case. Is that correct? That you've already talked about?
2 murder cases and 1 rape.
Okay. And you're providing the same services for those cases that you've already discussed that you provide for your clients?
Yes, sir. Yes, sir.
All right. I have no further questions for this witness, Your Honor.
All right, thank you. Mr. Smith, ordinarily you would be able to cross-examine, but under these circumstances, you're going to be able to present your own testimony in your case. So we'll move to Mr. Gentry's next witness. Is that all right?
Yes, sir.
All right, Mr. Gentry, you want to call your next witness?
All right. My next witness will be Kevin Richards.
Mr. Richards on?
He is.
Yes.
Raise your right hand, please. In the testimony you present today, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Lower your hand, state your name, spell it for the record, please.
Kevin Richards, KevinRichards.
Your witness, Mr. Gentry.
All right. Thank you. Mr. Richards, can you tell the commission what you do for the state?
I'm an investigator with the Regulatory Board's Investigations Division.
All right. And are you familiar with Reese Smith and Justice Now Press Civil Rights?
I am.
All right. And how did you become familiar with Mr. Smith and his business?
I was asked to investigate a complaint that was filed, and he was the respondent.
All right. And what actions or when was that? Do you remember when your investigation took place?
It was March of last year.
Okay. And what actions did you take as part of this investigation?
I initially made contact with the complainant, spoke with them, and then I went to Mr. Smith's residence and left my card, and he called me back fairly quickly. And we had a short conversation, and I told him the nature of the complaint and requested that he provide a statement. And about a week later, he contacted me and said the statement was ready. I met him at his residence, and he provided the statement. I notarized it.
Okay, so he provided you a notarized statement. Was that provided as part of your report to the state?
It was.
Okay. In Your Honor, I had indicated that on my witness exhibit list that Mr. Smith's affidavit would be one of our exhibits. I would like to make it an exhibit. This has already been provided to Mr. Smith, and I believe that we had discussed during our pre-hearing conference having these exhibits introduced since there was no objection to them as they'd already been provided. So would you like me to have, for efficiency, would you like me to have that email to the commission members now?
Mr. Smith?
Sir?
You recall that in our pre-hearing conference, you indicated you had no objection to those exhibits?
Oh, yes, sir. I had no objections.
All right. Yes, Mr. Duker, you may publish the statement or affidavit of Mr. Smith as Exhibit 1 and make sure you send it to me for
Yes, sir.
entry in the record.
Yes, sir, I will. Let's see, I think, Carol, are you still on the line? Carol McGlynn is my paralegal.
Yes, I'm here. I just emailed it to Shauna and I copied you.
Okay, do you have the judge's email address?
I'm not sure. I will have to look.
Okay, I can forward that to you.
Do you have the court reporter's address?
Yes, sir.
All right, just send it to the court reporter. That'll be fine.
All right. All right, so Mr. Smith, I will resume my questioning then, Your Honor. Mr. Richards, Mr. Smith provided you this affidavit that you notarized, is that correct?
Yes.
And did he also discuss what his business does, Justice Now Press Civil Rights?
He did.
Okay, and without having to get back into all of it, since you had heard his testimony, is that consistent? Did he tell you his business does the same work that's consistent with his testimony today?
Yes.
Okay. Was there anything that he told you at that, or that statement real fast? Was there anything else that he told you that was not provided in that statement?
Not that I recall.
Okay. And did Mr. Smith end up sending you some text messages as well as part of this investigation?
After I received the statement, he sent me a text and he requested that it be attached to the statement.
Okay. Did he make any other written statements to you? Was it just the affidavit and those text messages?
That was it.
And Your Honor, we have received those text messages at the same procedure as before. I had sent those to Mr. Smith. We discussed at the pre-hearing conference. I would like to make a copy of those text messages from Mr. Smith as exhibit number 2.
Be admitted as Exhibit 2. Make sure they're forwarded to the court reporter.
All right, thank you, Your Honor. And Mr. Richards, did you take, after you received those statements from Mr. Smith, what else did you do in terms of this investigation?
I just wrote my report and attached the statement as an exhibit and submitted it.
Okay. And Your Honor, I actually have no further questions for Mr. Richards. I think that he has testified with those documents as well. without getting too cumulative as to this proof, is pretty consistent with what Mr. Smith has said.
Mr. Smith, do you
Yes,
have
sir.
questions? Do you have questions for Mr. Richards about
Yes,
his
sir.
testimony?
Yes, sir. Mr. Richard, you have a copy of the complaint that you oh no, wait a minute. No, I'm sorry, Mr. Richards. That's not you. That's not you. That's Captain Weltley. So I was gonna ask you a question, something that he put out there, not you. But let me ask you a question. Had at any time that you was at my house, did you look on you saw my manor, you saw my preacher's license and everything, you saw where I even had a certificate doing the kind of work that I do, where I got honored for doing the kind of work I do with my business. Did you take any pictures of any of that?
No. That I recall. I don't recall taking any pictures of that.
Okay.
If I did, I didn't submit it with my report.
Okay. Now, when you saw my power of attorney, did you take a picture of that?
I didn't submit it with my report. If I did, I don't recall that.
Okay, because you did make a statement when you read it. Do you remember what you told me or said to me when you saw my power of attorney?
I don't recall, to be honest with you. It's been over a year.
Okay, because I remember when you said your power of attorney has nothing in there to indicate you being an investigator, because it states in there what you're doing, because you read my power of attorney. So my question is, did I ever tell you I was a private investigator or I was acting as a private investigator?
No, sir. You said you were not a private investigator nor a security guard. You were just an advocate for the families.
Okay, so how did it come up that I was a security guard?
Because you had a uniform on, and that was mentioned in the initial complaint, and they didn't know they didn't say you were acting as a security guard. They just said they thought it should be looked into because you were wearing a uniform at the time of the interaction.
Okay, and I told you before my boss died, he was a retired Marine, and I was ex-military myself. We wore uniforms in Florida while I worked in Florida. I told you that. I said we wore uniforms there. And then after he died and his wife gave me the business.
Your Honor, I'm going to object. I think this is testimony at this point.
Oh, I'm sorry. Well, if it is, I apologize. But I was just asking questions that I brought to his attention. That's why I was asking him. So, I mean, after you and I sat down and talked, and you saw all my exhibits that I use my business, did any of those exhibits on there say that I conducted private investigation work for families?
No.
So none of the witnesses you talked to, or nobody you been around said, I told them I was a private investigator. The only thing y'all said was I was in uniform.
Objection to hearsay, Your Honor.
If he talked with him,
only ask questions. You can't go into this explanation of what you think it is or whatever. Just ask the question and let the witness answer.
Okay. So nobody never told you I was an investigator?
Repeat the question.
Nobody never told you?
Mr. Richards, we need to have your answer.
Okay. Did anybody ever tell you I was an investigator?
Okay, that's the question. Mr. Richards, your answer.
No.
Thank you.
Okay. All right. That's going to be all. Thank you.
All right.
I'm done with questions.
Mr. Valentine, do you or your commission members have questions for Mr. Richards? You'll be able to pose questions to Mr. Smith after his testimony, which would be in the nature of his cross-examination of himself, the way this proceeding is going. But do you have questions for Mr. Richards? I'm
Question.
sorry, sir, we cannot hear you.
Bain has a question to Mr. Richards. Mr. Richards, did you record any meetings with Mr. Smith?
I did not.
Do any other commission members have a question for Mr. Smith or Mr. Richards?
Mr.
Hearing
Russo,
none,
you
Your
indicated-
I believe Mr. Russo raised his hand. Commissioner Russo, did you have a question?
Yes, I do.
I'm conducting the hearing, Mr. Gentry. Mr. Russo, you're recognized if you have a question for Mr. Richards.
Yes, Your Honor. Well, I have a question for Mr. Smith. I'm sorry.
All right, we'll hold those until Mr. Smith completes his testimony.
Oh, I'm done asking, I'm done questioning, Your Honor.
Yeah, I understand that, sir. Mr. Gentry, do you have other witnesses?
I would like to ask just Executive Director Cody Vest a couple questions.
All right.
Cody Vest, are you there still?
Yes, I'm here. You can hear me?
Yes.
Raise your right hand, please. In the testimony you give today, do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Lower your hand, state your name, spell it for the record, please.
My name is Cody Vest, C-O-D-Y-V-E-S-T.
Thank you. Mr. Gentry, your witness.
All right, thank you. And Ms. Vest, can you tell the commission your role with the state?
Yes, I am the Executive Director for Private Investigation and Polygraph Commission.
All right, and do you maintain the database for the licensed private investigators and private investigation company?
Yes, we do.
All right, and are you aware of any private investigator license for Reese Smith Jr., the respondent in this case?
No, sir, I looked on our core database, which is the state's database, and I did not find Mr. Smith on that database.
All right, and how about for Justice Now Press Civil Rights? Are you aware of a company license for that company?
I did not find the company license either.
All right, thank you. I have no further questions.
Mr. Smith, do you have questions for Director Vest?
Yeah, why would they have to involve you when my business is not in private investigator business? And you know, what are y'all fishing for? I mean, what was the use of contacting you?
Your Honor, I'm going to object. This is outside the scope. She just testified that he doesn't have a license, and now we're getting to these opinions.
I understand your objection. Mr. Smith, the questions on direct was whether she observed the state database to see if you did or did not have an investigator's license. Do you have any questions about that examination?
But Your Honor, my business is not a private investigator business. So why would
I understand that's your contention. This commission is convened to determine whether your actions qualify as investigator, whether you should have had or should not have had. That's an ultimate decision for this commission to make, not Ms. Vest. Her testimony was restricted to whether it appeared that you did or did not have a license.
Okay, well, right. I'm gonna object for her statement and the use of her testifying. So I have no questions for her, Your Honor. I'm done.
All right, your objection to her testimony is on what basis?
On basis that, I mean, my business is not a private investigator, so Mr. Gentry had no reason to contact her to do any kind of research on me because The state of Tennessee gave me my business license, not the private investigation.
All right, your objection is overruled. It's not relevant to the question that was asked to her. I believe you have already admitted that you do not hold an investigator's license because you don't believe that you should be required to have one. I understand that's your position, but her testimony is simply that the records of the commission don't reflect you have a license, which is something you agree with, correct?
Yes, sir. Yes, sir.
All right, so I'm overruling your objection. Mr. Gentry, do you have another
sir.
witness?
Your Honor, I have no further witnesses.
Thank you. Mr. Valentine, do you or any of the other commissioners have a question for Ms. Vest?
I do not, Your Honor. Do any of the other commission members have a question for Executive Director Cody Vest?
All right, hearing none, the state has rested its case in chief. Mr. Smith,
Yes, sir.
this is your opportunity now to present your case. Do you want to resume your testimony?
Yes, sir, because I like to call, yes, sir. I like to call,
Would you like to complete your testimony?
no, I still want to call my witnesses I subpoenaed, sir.
All right, so you don't intend to provide any further testimony yourself, or you want to wait until a later
I'm gonna
point?
wait. I'm gonna wait till after I'm done questioning my witnesses.
Thank you, and your first witness then is whom? Who do you wish to call as your first witness, sir?
Captain Wealthy.
Is Captain Welty available?
I am, Your Honor.
So raise your right hand, please. In the testimony you provide today, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Lower your hand, state your name, and spell it for the record, please.
William Welty, William Welty.
Thank you, sir. Your witness, Mr. Smith.
Captain Welty, how long have you been working for your company?
I've been with the city of Clarksville for approximately 5 years.
And started when?
Around 5 years ago, sir. If it's 2021, that'd be about 2016.
2016, okay. All right. Before the complaint was filed, have you ever seen me in your building?
I have.
Okay, and do you know why I was coming to your building?
No, sir. We receive visitors through our city hall building daily for various reasons.
Okay, so you never see me come up there, request cops records or pick up their files?
No, sir. Not that I recall.
Okay, you were there in 2016, then I'm quite sure you should have saw me at least 10 times requesting officers' records.
We see
So you
hundreds
don't
of people a day, sir. I can't remember every one of them.
Okay, so how did you come about this complaint on me?
This complaint on you was filed in reference to an incident at our Clarksville Gas and Water location at 2215 Madison Street. Sergeant Guy Bowen, who was the officer on duty that day, filed an incident report about his interaction with you.
And after the interaction with him, I came down to see you, did I not?
No, sir, you didn't come down to see me after that particular interaction on February 25th, 2020.
Oh, we didn't. So are you saying I never came down and we had a face-to-face conversation, sir?
We did on June 7th, 2021 at Clarksville City Hall desk at 11:45 a.m. We spoke for around 20 minutes. I have a body camera video of that interaction.
Just for clarity,
2021, I apologize, sir.
2020, is that what you're referring to? We haven't quite made it to June this year.
My apologies, sir. On June the 7th, 2021, or 2020.
Thank you. Thank you.
2020, myself and Mr. Smith spoke at 11:45 a.m. for around 20 minutes. I do have body camera video available of this conversation.
Okay. I just want to make sure we did talk. Okay, so you already confirmed that you and I did speak face to face that day. Okay. All right. And you're saying you don't remember seeing me coming down there to the license place, picking up my business license?
As I stated earlier, sir, we have hundreds of visitors a day in our building. I cannot remember everyone who comes through the building.
How many of them come through with uniforms on?
It depends. There's police officers in here. There's deputy sheriffs in here from time to time.
Sir, I've always wore a white shirt and black pants.
Your Honor, I object to the relevance of this. We're outside the scope of why we're here today.
I'm trying to prove that he has seen me there before, Your Honor.
Mr. Smith, it's not relevant that he saw you there or not. He's said that he doesn't recall it. You've asked the question, he's given you an answer. It doesn't mean that you weren't there. He didn't testify that you didn't come. And whether you were there or not in the past is not relevant to the issues in this case.
All right, so did your guard tell you that I was a police officer?
Your Honor, object to the hearsay.
Overruled.
If he spoke to his own guard, he should be able to know. Oh, thank you, Your Honor.
I overruled the objection.
Okay. Did your guard tell you I was?
Mr. Welty, you can answer the question if you know the answer.
No, sir, he did not state that you were a police officer specifically.
Okay, what did he state that I was then, sir?
So according to Officer Bowen's incident report that he filed on February 26th, he states that this individual entered the building.
I'm objecting. I'm objecting. I'm asking you what he said. I'm gonna ask you what you reading from your report because he's not here to confirm what he told you. So I can't question him. So I'm asking you, did he tell you anything else other than who I was?
Judge, I hate to interject because I know the city's not a party here, but could we get it, could the questioner, Mr. Smith, make it clear whether he's referring to the February 25th, 2020 incident, or is he talking about the incident on June 7th, 2020? Or is he talking about the February 3rd, 2021, or the April 7th, 2021 interaction? There's 4 different dates involved. And by the way, Officer Bowen is present to testify.
Okay. Well then, thank you. All right, then I'll question him.
Listen,
I'll question him after I get through. Thank you.
Mr. Smith. Mr.
Okay.
Smith.
Thank you.
Mr. Smith, listen to me.
Yes, sir.
When you ask a question, you need to give the witness an opportunity to respond.
Yes, sir. Yes, sir.
All right. You ask for hearsay. You can't then object to hearsay when it's being presented. Do you understand?
Yes, sir. Yes, sir.
All right. Thank you. Now, do you wish to respond to the question? Do you have information about Mr. Smith's last question to you was how was he described by Officer Bowen?
Yes, sir. He was described by Officer Boeing as what appeared to be a type of security or police uniform. This person was wearing a black baseball cap with captain bars in the middle, and the word agent was embroidered on the right side. His shirt was white, unmarked, long sleeve dress shirt with gold captain insignia pins on both collars, black pants, a black nylon duty belt. The belt contained a double magazine carrier, empty, a handcuff case, cell phone, and badge clip with a gold security badge that had black electric tape covering up some of the words on top of it. What's that?
All right, thank you.
This was on 2/26/2020.
All right, Mr. Smith, does that answer your question?
Yes, sir.
All right, do you have other questions?
Yeah, give me a minute, y'all. Let me look at something. Did you handle reporting, Captain?
I was not there, Mr. Smith. Officer Bowen submitted the report to me.
Did you ever submit a report?
Did I ever submit a report? No,
Yes,
sir, I would
sir.
not have submitted a report because I wasn't physically present at the time of the interaction. I am a supervisor. I review reports submitted to me by my officers.
Okay, then why do I have an incident report with your name on it?
My name appears on all our incident reports due to the programming software. It shows that I have reviewed said report. It's an audit trail that shows who has laid eyes on it. So my name will be on every incident report for the City of Clarksville's Loss Prevention Department at the bottom, showing that I have indeed read and reviewed the incident.
Okay, so I have one. Well, I got your name on it for one. Section, how do I receive you? That's a report that you gave with your information on it. And then you have on it just now press attorney in fact, pastor, and you know what attorney in fact is? Because that is my title as well, attorney in fact. Have you ever looked that up?
No, sir, I'm not. I believe it's just a legal terminology, not necessarily a profession.
No, it's not a profession. I said, you understand what
Your Honor,
attorney in
I'm
fact
going to
is.
object to this line of questioning, Your Honor.
Mr. Smith, you can't argue with the witness. You can ask him questions, get his responses, and move to your next question.
Okay. You have on the possible impersonation of licensed professional. What kind of licensed professional do you feel like I was impersonating?
Well, sir, so after a review of the incident report and the statements made by the customer service representatives, as well as taking a look at the photograph from the gas and water video cameras, while wearing a badge alone is not against the law when you consider the combination of the type of clothing you had on, the wording, which stated agent, captain's bars, which allude to status or rank in an agency or paramilitary type force, a duty belt with a pistol magazine case, the handcuff case. This would lead an average individual to believe that this person could be some sort of security or law enforcement personnel. When you combine that with the behavior that you displayed and the statement made to Sergeant Bowen that I'll investigate you if I want to, cause some concern that you may be holding yourself out to be some type of agent or officer. Also, with you wearing a pistol magazine case but no holster for a weapon, that raised some reasonable suspicion as well. Normally, when you see a magazine case, that would allude to some type of firearm being possibly available to you. Public record search of the Department of Commerce and Insurance's website for licensed security officers, armed or unarmed, and private investigators did not return any results for Mr. Reese Smith, a business license was located for the city of Clarksville and described your business as attorney-in-fact, Pastor Reese Smith. Also, an internet search revealed that you were convicted of aggravated perjury and sentenced to 6 years and 1 month suspended to 8 years of supervised probation. You were also convicted of 2 counts of impersonating a licensed professional. Based on this information,
Object to that, Your Honor. I'm objecting because of what he just done. No, sir, because number one, those two charges, impersonation, was expunged, sir. So I don't know how you come up with that information or who you went through to get it, but you just defamed my name. I don't like that.
Smith.
So you just caused your, no, he's crossed the threshold, Your Honor. No, he just did.
Mr. Smith, you asked him why a report had you listed as possibly impersonating an officer, and you're giving an answer. If you don't like the answer, you can address it in your own testimony.
I will.
Okay, so your objection is overruled.
Okay.
Does that complete your response to the question?
Almost, sir. Almost.
Go ahead, finish. Go ahead and finish.
I consulted with our city attorney, Mr. Lance Baker, and he advised me to forward up our reports to the appropriate regulatory agency to look into this matter further, which I did.
And what'd you find out?
I didn't find out anything, sir. We forwarded it to the appropriate regulatory agency having jurisdiction to look into it.
And how long has that been?
Mr. Smith, that resulted in the issues that have us before the commission today.
Okay.
Thank you.
March 2nd, 2020.
Do you have any questions, any further questions for Captain?
No, sir.
Sir?
I have no further questions for the captain.
All right. Mr. Gentry, do you have questions for Captain Welty?
Just one, or one line of question, I suppose. Captain Welty, I believe the attorney said next to you had indicated that there were multiple incident reports with Mr. Smith. Approximately how many incidents has Mr. Smith had with the Clarksville City office?
So on February 25th of 2020, that was the initial contact at our gas and water location.
That's it.
On June the 7th, 2020, at Gas and Water Customer Service Center, 2215 Madison Street, there was an incident report filed. Video available. On June the 7th at Clarksville City Hall at the security desk, as I stated earlier, I spoke with Mr. Smith for around 20 minutes. On February the 3rd, 2021, at the Clarksville City Hall security desk, we spoke with Mr. Smith, myself, Officer Wilm, Officer Gallo, and Officer Baldwin were present. On April the 7th, 2021, at Gas and Water Customer Service Center, 2215 Madison Street, we had another incident report with Mr. Smith, Officer Bowen, Officer Placencia, Mr. Bronson Gibbs, Miss Brandy Gerald were present during that incident. On April the 7th, 2021, at Clarksville City Hall, we spoke with Mr. Smith again, and he came up to see our city attorney with his subpoenas.
So other than the, other than the incident where he was meeting with you all to discuss the subpoenas, there's 6, is that right? 6 incidents?
Around that, yes, sir.
All right, no further questions. Thank you.
All right. I'll remind the commission that only, Mr. Welty, you're not excused yet. Mr. Welty, you're not excused yet.
Yes, sir.
I want to remind the commission that matters outside the scope of the notice and charges are irrelevant to your work today. So any reference to incident reports that were not referred to in those notice and charges, you may disregard. So Mr. Mr. Valentine, as chair, do you have questions, or does any other commissioner have questions for Captain Welty?
Fellow Commissioner, anyone have questions for Officer Welty? Your Honor, I do not, and I don't hear any response from the rest of the commissioners.
All right, thank you, Captain, for your testimony. You may be excused. Of course, this is a public hearing, so you may remain if you choose.
Yes,
All
sir.
right, Mr. Smith, do you have other?
Yes, sir. Yes,
witnesses?
yes, sir. Shayna Lemongood, is that how you pronounce her name?
Unita McLeod?
Spell the
Shayna,
name, Mr. Smith.
what's her
Sir?
last name?
Spell the name.
Liebengod. Lemongood.
All right, Shayna Livingood was a
Yes.
former employee of Clarksville Gas and Water. She's no longer employed by Clarksville Gas and Water. And to my
Okay.
knowledge, there was no subpoena served on her, but I don't know that it was served.
Okay, then give me Miss McLeod.
Raise your hand, please. In the testimony you give today, you swear to tell the truth, the whole truth, and nothing but the truth. I can't hear you.
I do.
Lower your hand, state your name, and spell it for the record, please.
It's Unita McLeod, UNEEDA
You're going to
I'm
have to
sorry,
move
Your
closer
Honor.
to the microphone.
Thank you.
We cannot hear you.
My name is Unita McLeod, UNEEDA
Thank you. Ms. Ailes, was that adequate?
Yes, Your Honor, thank you.
All right. Mr. Smith, your first question.
Yeah. You have a copy of your report that you gave?
Yes, I do.
Can you read it, please?
No, sir. You may ask
Yes,
a
sir.
question. You may ask a question. Reading the report is not appropriate. We're not going to just fill up this record uselessly with a report. If you have a
Okay.
question,
Who do you speak with when you gave your report?
I didn't speak with anyone. I was asked to write a report from when you came into the office that day when you had the altercation with Guy.
By who? Who asked you to write the report?
Our security guard, Guy Leo.
So the report you gave, was that your own report, or did he tell you words put down?
No, that was my report.
So in your report, what did you say about me?
What I said about you in the report is that I witnessed you leaving the office from paying your bill, and then you went to your car, you came back up to Guy because he had stepped outside to make a phone call, and you seemed like you were very aggressive with him at the time. At that time, Guy brought you back inside the building, gave you a card, and you told him, if you ever investigate me again, I know something.
No, let me see. No, I didn't say if you ever investigate me again, I know something.
Your
That's
Honor.
not what I told you.
Mr. Smith,
Yes,
you
sir.
may not argue with the witness. You may ask questions and receive answers.
Okay. Did you say I look like a cop the way I dressed?
I never said you looked like a cop. What I said was when you walked in and I saw your badge with your tape on it, I figured you had a fallen comrade. So you could have been anything. What? I don't know. But that was my observation.
And I did, my boss. That's who I represent when I go, is my boss.
Mr. Smith, this isn't your time for testifying. You can ask questions and receive answers.
Okay, well, I'm trying to read her statement here, Your Honor. That's what I'm looking at, because in order to ask her a question, I got to understand what she said.
You should have read it before this hearing. Now you can ask the questions.
Well, that's just it, Your Honor. I can't make out because of her writing is light and is not showing her statement
What about
clearly,
it
sir.
is relevant? What about it is relevant to the issue of whether or not you were engaged in private investigations?
Okay, hold on. Okay, can you lie me a couple minutes, John? I'm trying to look at this and go through so I know what questions to ask her, if you don't mind. Okay, Your Honor, I wouldn't even, only thing, okay. I can't make her report out. It's not clear. And it's just like her name, you can see her name, but as far as her report, it's not making herself clear what she said. But could you give me an idea of what you were telling Mr. Guy?
What do you mean? What I
What
was
did you and
talking?
Mr. Guy discuss?
I didn't discuss anything with him. The only thing he asked was, did I see what went on between you two? And I gave my observation of what went on between you two. That was it.
Okay, so you never gave any insight of, you thought I was impersonating an officer or a security guard?
See that on my report? It's not on the report.
Okay, I'm just asking you, you never insinuated that?
Mr. Smith, whether you did or did not do anything that was impersonating an officer, that's not the issue that's in front of this commission today.
Okay, well then, I have no more question. I have no question for her then, because
thank you. Mr. Gentry, do you have questions?
No questions. Your Honor, I would move to strike this testimony. I don't think it was relevant to anything before the commission
yeah,
today.
I agree with him. I agree with him.
Mr. Valentine, does the commission have any questions?
I have no questions, Your Honor. Do any of the other commission members have a question for this witness? Hearing none, Your Honor.
All right. Thank you, ma'am, for your testimony. Mr. Gentry, I'm not going to strike it. I agree that it has very little, if any, relevance, but that's for the commission to decide if they weight it or find any evidentiary value in anything she said. Again, ma'am, you may be excused, but this is a public hearing, so you can remain present if you choose to.
Thank you.
Okay.
Mr. Smith, do you have any other witnesses?
Okay. No, I'm just, now, the lady that they said that the attorney said used to be with him, was that Miss Liebengood? Is that the one you said that is no longer working there, sir?
Yes.
Correct.
Okay, okay, okay. All right.
Do you have any, Mr. Smith, do you have any witnesses you think are going to help your case?
I'm looking for Mr. Hello? I thought you was, I'm looking for the other person, Your Honor. Trying to make out his name right now. Is it a he?
If you don't know who your witness is, we certainly don't.
No, Your Honor. I'm trying to, I know who he is. I'm trying to locate his name on here. Oh, okay. I'm sorry. Mr. Guy Bowen. That's the one. I'm sorry. I got it. Guy Bowen.
All right, Mr. Bowen.
Judge, he is here. He was never properly served with a subpoena, but he's here.
Your Honor, I would renew my objection. I don't have any records of Mr. Bowen at all in this case. I know you had stated those subpoenas that were filed were public record, but I don't have any record, and there was no witness and exhibit list that was filed.
All right, thank you. Mr. Bowen?
Yes, sir.
Would please raise your right hand. In the testimony you give today, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Lower your hand, state your name, spell it for the record.
It's Lael Bowen, Laelbowen.
All right, Mr. Smith, you'll be permitted to ask questions that are relevant to this hearing, okay?
Yes, sir. Mr. Bowen, damn. Excuse me?
I'm sorry?
Oh, I thought somebody said something, sorry. Can you give me a background of what happened the day that you and I clashed heads together, please?
Which day are you referring to?
February 25th.
I believe that was the first interaction that I had with you. On that particular day, what I recall, you came into the Gas and Water wearing a security uniform. As with the nature of our business, it's almost customary from one professional to another to ask who you work for. All I asked was, which company and who do you work for? To that question, you took offense to, sir.
Do you have another question?
Yeah, well, he just stated something that's not true, but why would you call it security uniform? Was security on the uniform? Did it have security on the shirt?
On the badge, the gold badge that I observed had the word security. And there was no patch. There was no company patch. So I simply asked, who do you work for?
And what I tell you?
You said you didn't work for anybody, that you work for yourself.
Okay. And did I give you the name of my business?
Not at the time, you did not.
When you approach me, if I'm not mistaken, the way you approach me offended me, for one, because you got kind of like coming to my face and you kind of look at me like, what am I doing?
Mr. Smith.
Yes, sir.
You have a question.
You said I didn't tell you anything, and I didn't tell you about my business or anything.
No, sir.
Well, tell me what you remember between us, because I mean,
I just did.
You gave a long story right here, so tell me what you felt.
Interaction escalated after I asked you who you work for. You said you work for yourself, and that you weren't going to answer any more of my questions, and you walked out.
And then I had proceeded to go to lunch. And while I was on lunch, one of the ladies came back and said, "Hey, Mr. Smith is back. He would like to talk to you." I left lunch and I came back to talk to you, to address whatever concern you had. And you had if I remember, I said business license? You had a business license. You had a business license in your hand. And you told me, "I don't like people like you looking me up and down. What I have here is a license that gives me the right to do what I do." Something to that effect. And I simply asked, "Okay, what do you do?" You said you investigate people. You used that exact word, investigate. And you told me, "Don't you ever do that to me again."
I object for number one. I object to that, Your Honor, because right now it's hearsay. Do you have proof that I said I was an investigate? That I investigate?
No, sir. You may not object. You've asked this question. He gets a chance to answer it. In your testimony, you can give whatever story you want to about that incident. This is his testimony, and he's permitted to answer your question. Go ahead, Mr. Bowen.
Go ahead.
And then in conclusion, he told me, "Don't you ever look at me like that again, because I will investigate you if I want to." That's when he turned and he left.
Thank you. Any more questions, Mr. Smith?
Yeah. Do you have a copy of this? Do you have a copy of this recording saying what you just said I said to you?
Not at the time, no.
I'm going to object to his whole testimony, Your Honor. I'm striking because if he's going to testify on what I said to him, he should have proof that I said it.
Mr. Smith?
So I'm asking for his whole statement to be stricken because that's hearsay.
Mr. Smith, you called him as a witness and you asked the question. It won't be stricken. These are responses. You didn't have to call him as a witness.
No, but Your Honor,
I'm sorry.
But Your Honor, they have the little recordings that recorded me. So he should have bought it to present what he's saying.
Mr. Smith, did you subpoena recording?
Yeah, I told them to bring whatever they had. I wanted the subpoena, I wanted the recordings, a statement.
Did you subpoena a recording? You didn't subpoena the city of Clarksville. And at this point, I'm wondering if it's even relevant. This is his testimony. You'll be able to give your testimony. If there isn't any specific subpoena, look through all of them. There were, problems with them. I'm trying to give you greatest leniency I can in presenting your case, but your subpoenas ask the witnesses to come to a live hearing, in Nashville. They've gone out of their way to cooperate to be available by WebEx. So there wasn't anything in your subpoenas that were directed to the keeper of records for the city of Clarksville to obtain any kind of recordings or anything of that nature. So I'll just have to deny your request to strike the witness. I'll ask you if you have any other questions or if you have any other witnesses that are relevant to the issues that are before this commission.
Yeah.
I'm sorry, Mr. Smith.
No, I'm looking. Yeah, I'm looking at a statement that he wrote. Yeah, I'm reading this statement right now, Your Honor. I'm reading the statement, then I'm asking questions.
Do you have questions for this witness?
Okay.
Is that yes or no? Do you have any other questions?
I'm sorry. Yeah, I'm great.
I'm not sure I understand what I'm good means in relation to you
I'm
have
sorry,
other
Your
questions?
Honor. I was looking at something and I was going to ask him a question and you,
So you do have a question?
yes, I do, Your Honor.
Pose the question, please.
How, you said my uniform looked like security uniform, right?
Correct.
What made it look like a security uniform?
Well, the fact you were
Mr.
wearing a
Smith, you've
duty
already
belt
asked
for one
that.
thing.
Just a moment, just a
And I
moment.
on duty
You've
belt.
already asked that question.
Hold on for a minute, Judge talking.
You've already asked that question, and he said that he saw the word security prominent on your badge. Do you have a different
Okay.
question?
Okay. Now you said you was describing my belt. What
Do you
was it
have a
on my
question?
belt? Yeah, I'm asking him. You describing what I had on my belt. What did I have on my belt to warrant you that I was anything other than an agent?
A gold badge. With the word security.
Okay, we've been having. Okay. But that gold badge don't really insinuate anything, does it?
Your Honor, I'm going to object. This is not relevant
Yes.
to why we're here.
I'll sustain that objection.
But Jonna, everybody is trying to insinuate something that I'm not. So all I'm saying is, if they insinuate it, then they should be able to explain it.
What they testified to is your appearance and your apparel. What they assumed or requested an investigation of is in the bosom of this commission to determine whether you conducted yourself in a manner that would bring you under their, under the statute and require you to have a license as an investigator. That's up to the commission, not to the witness. They've testified to the facts of what they observed. That's all that they can do. Their insinuations are irrelevant. All right?
I hear you, Your Honor.
All right, do you have any other questions?
No, because what he asking here is just, it's not even important, because as long as it's not even important, Your Honor. I'm done questioning him. No, I don't have no more questions for him.
Thank you. Mr. Gentry, do you have questions for Officer Bowen?
No, Your Honor.
All right, Mr. Valentine, do you or the commission have questions for Officer Bowen?
Any other commissioners have a question for Mr. Bowen?
This is Bain. One question. Let's start my video. One question. That question is, while there may not have been any audio recorded, was there any video recorded at the February 25th, 2020 interaction?
No, not with this interaction, no.
Thank you.
I have no questions, Your Honor.
All right, then. Mr. Bowen, thank you for your testimony. You may be excused as a witness. Again, this is a public hearing, so you may remain present if you wish.
Thank you, sir.
Mr. Smith, do you have another witness?
No, sir.
Do you wish to testify now?
Yes, sir.
Proceed.
Mr. Gentry, would you like to question me, or anyone else like to question me? I have questions for me, sir.
Mr. Smith, do you have any more testimony to give? I conduct the hearing, so I'll direct when questions are appropriate to you. But do you
Yeah.
have any more testimony?
Yeah, about me and my business. Yes, sir.
Those are the things that are important in this case. Yes, you may offer your testimony now. Anything that you haven't
Okay.
testified to in your direct examination by Mr. Gentry.
Well, Mr. Gentry was, did you have a question, Mr. Gentry? Then I'll start from there.
Mr. Smith, you start with your testimony. If you don't have anything else, I'll ask if there are questions from the board. There's already been an indication that they have a question for you. But if you have testimony, in addition to the things that you said in response to Mr. Gentry's question, this is your opportunity to present those facts.
Well, Mr. Gentry was questioning about my business, what I do. Justice Now Press has been a helpful ministry, helping people, working with people. And I don't know how we get to this point where Mr. Gentry is questioning about private investigator license when I'm not a private investigator. I'm a civil rights advocate and I help family members. So I don't know how we get to this certain point that I'm acting something that I'm not. And we help family members, been helping family members. I went to school to be a criminal paralegal. So I do a lot of research. I work with lawyers. I work with several lawyers here in Tennessee, and they have been very successful with their cases. The main lawyer that I worked with, Mr. Harry Christensen, who I've been with since 2003. The reason why I didn't want him to come in and represent me because he had other things to do. He had other cases that I would not take him away from. I don't see anything wrong with what I do or what I'm doing. Simple fact, because when families come to me, I help them. I'm not a private investigator, never have been a private investigator, never have conducted myself as a private investigator, because I don't have to go look for the information or find information. They have it in the court files or the court papers or the transcripts that I get. And everything that I read and look at, I'm going on what's already there. So I don't have to go and look for nothing. It's already in the paperwork. It's in the transcripts. And the only thing I'm doing is going back to find out if what was done in transcript true. I don't have to go do no investigation because it's all right in front of me. Mr. Gentry keeps bringing up private investigator. I'm not a private investigator, never have been. But the kind of work I do, I'm good at what I do. And I've helped many families go home and not to prison. I've helped 4 families get out of prison. I have spoken to judges, spoken in front of indictments. I mean, I have sat in front of judges and have talked. I have testified on behalf of a lot of things I do. I've never been arrested for anything other than what other people tried to make me out of, and then come to find out they have to dismiss the charges because it's not true. I've never impersonated anything other than agent. I am a licensed minister, I'm a licensed elder and pastor. I was a pastor for 3 years at a church, but I gave up the church because of my business. I stayed on the road a lot. But I'm still recognized as elder pastor because I still teach. I do seminars, and I give people knowledge what they need to know for themselves. And I don't work without having somebody giving me the authority to do the work for them. I don't make steps without their power of attorney telling me to make steps. I don't collect anything without them putting in there, pull the police record. No matter how many cops it is, if they got 9 cops, I pull 9 cops. But it's on their authority, it's under their orders and their guidelines under the power of attorney. So when I got arrested in Jackson, Tennessee, and sat for 5 months and got released after they realized we really don't have a case, they set me in there because they don't want me to submit the evidence to prove that the guy didn't rape his stepdaughter. And then when I had to come back to Nashville, I had my own hearing in front of Judge Fishburne. He reinstated me because I didn't break the law, because the family member was there to testify. We gave him the power of attorney, showed him the power of attorney, and Judge Fishburne said out of his own mouth, as long as you got power of attorney, Mr. Smith, you can do what you do. But if you're doing it without power of attorney, then it's like you acting
Your
on
Honor,
your own.
I need to move to strike that and say that is clear hearsay.
It is hearsay.
He said I get a chance to tell my side and talk, so I'm telling you how this come about. So it's not
Okay,
hearsay.
Mr. Smith, it is hearsay because you're repeating words that you're attributing to this judge who is not here present to testify. That's hearsay.
Oh, okay. As long as I don't mention names, then I'm good. Just don't.
As long
Okay.
as you
I
don't
see what you're saying.
say what somebody said and present it as truth.
Yes, yes, sir. Yes, sir.
Thank
So, thank you, Your Honor. So in my years of doing what I do, I have never been questioned. I have never been asked by anyone other than people who think I'm something I'm not. Then when they realize what I am, then they leave me alone. I don't even know why we came this far, because I haven't broken no law. I have every right to help people. I have every right to contribute my knowledge, my experience, and what I've been taught working with lawyers to teach. I do seminars every month. I'm on Facebook talking to people, giving them directions and giving them guidance of what they need to do for themselves. So if I'm breaking the law, then I should be arrested for giving any advice to family members that has helped them help themselves. So, Mr.
Anything
Gentry,
else?
what wrong do you see what I'm doing?
Do you have any more testimony?
No, sir. I would like to question Mr. Gentry if I can.
No, you may not. He's not a witness. Mr. Gentry, you have already interrogated Mr. Smith. Do you have additional questions?
I just want clarification on one thing. Mr. Smith, you said you gave up working for the church because of your business. Which business was that you said your business was expanding? Which business is that?
Falsely accused.
Okay, which then became Justice Now Press Civil Rights. Is that correct?
Right, right.
Okay, perfect. I just wanted to make sure. Thank you.
Yeah, it was falsely accused then, and then I changed the name to Justice Now Press because I cover stories, I interview people, and I have that right. So as a press agent, I interview a lot of people, question a lot of people. So
Thank you.
I haven't done anything wrong that has not allowed me to do.
All right, thank you. Mr. Valentine, do you have questions? I know that Mr. Rousseau indicated earlier that he had questions.
Yes, Mr. Rousseau, go ahead and ask your question.
Your Honor, my question was answered through the questioning of Mr. Smith to his subpoenas.
Okay. If that's the case,
Mr. Valentine, any other questions?
yes, Mr. Smith, you mentioned a couple of times that you said your PO. What does that mean, your PO?
Probation officer.
And what were you on probation for?
Aggravated perjury, they said.
Okay. Any other commission members have a question for Mr. Smith?
Yes, I do.
State your name, please.
Stuart Bain.
Who's that?
Mr. Smith, have you worked for more than one attorney?
There you go. Excuse me?
Have you worked with more than one attorney?
Yes, sir.
How many would you say you've worked with?
Ooh. Are you talking about just around or Tennessee?
Yes, sir.
Somebody in Tennessee?
Yes, sir.
Ooh.
No, ballpark it.
Over 100.
You use the phrase, when you're seeking information, you use the phrase, quote, find out if it is true. You remember that? You said that a few minutes ago.
Yes, sir.
Let me ask you this. How do you find out if the information is true?
That's easy, sir. You read the person's statements and you see what they said in the statements. And you know, after a while, that person either gonna come out with the truth or tell the truth.
And how do you determine that is the truth or not the truth?
Well, for number one, I'm videoing you, what you're telling me. So if you're telling me that what you said in court 5 years ago wasn't the truth because you were threatened or you were scared or put into coercion, then that's when I ask you, well, what really happened? And they tell me what really happened. And I say, okay, so this is the truth that you telling me now? Yes. I said, okay. Then I go and say, look, I get in touch with the lawyer. I say, I got something for you. He said, what's wrong? I said, well, the client for the state said that's not what happened. He said, how do you know? Oh, I got it here on CD. I'm gonna make a copy because I'm gonna keep the original and I'm gonna send it to you. And that's when they say, oh, now we can file because they lied. They commit perjury in court because they know they're gonna get in trouble, but you told the truth. And that's what it's time for the truth to come out. That's how I deal with if they lie, tell the truth.
So is it fair to say you investigate whether people are telling the truth?
I don't investigate. I'm there, listen to their side of the story, telling me now they want to change their story and tell the truth what really happened. And I say, okay, I'm going to record you and record your statement, what you're saying, because I'm not going to take this. That's not investigation, sir. That's just sitting there getting to the facts.
Right. So what you're saying is you determine whether a person is telling the truth or not.
Yes, sir, because I'm recording them.
My
And
next
whatever they
question,
tell,
my next question, sir. How many times have you been present in testifying in court? Since 2000? Just ballpark it.
mm, let's see. Ooh. I can ballpark it, but I'm not because most of my clients, Lord, it's been some years. I don't know where they at, so I'm not going to say something that I can't prove
That's
and have them with me. So I'm not going to give them.
I understand your answer. So more than one,
Yes, sir.
more than 5.
I would give it a ballpark. I would say if I could find most of them, I would say 20. I know I could find to prove, but we talking about.
Okay, that
talking about
doesn't, it leads to my question of, has any, under cross-examination, has any attorney ever challenged you as an expert or challenged you on opinions?
No, sir.
Last question. Why did you choose to wear a uniform, a badge, captain's bars, and a belt with handcuffs?
All that, I had my uniform when I was with my boss in Florida, Mr. Williams. In 1984, when I started my business, he was a lawyer that was watching me. And he would watch me for a while. And when he realized, he said, you know what? You're very smart and knowledgeable. He said, what are you doing? So I told him the reason why I'm helping families and the reason why I'm getting involved with the families. And he said, well, come to my office and talk with me. So I went to his office one day and talked with him. And from that day on, I was working with him. I was his delivery person, going to pick up records, files, whatever. Then he sent me to school for paralegal. And so after I got through, then he gave me more responsibility of teaching me about courts, what needs to be done. Because one time he couldn't make it to Atlanta. And he sent me to Atlanta just to go and talk to the guy and the family, let them know what's going on, the reason why he couldn't make it. So while I
Mr.
was
Smith.
there,
Mr. Smith,
yes, sir.
let me remind you that the question was, why did you wear a uniform? So you need to respond to that
I've been
question.
wearing uniform. I've been wearing uniform since 1994, sir. And we always had our we wore handcuffs. We was out in the field because I ran up on a couple of situations where when you question people about something and they don't want the truth to come out, and I've had guys, I worked as a bounty hunter for 5 years. So I was always in uniform. always been in uniform. So
Right.
when I,
Thank you,
on my
Mr.
belt, the my side that I had my handcuffs. That's for me in case somebody get crazy. I'm gonna detain them until the cops get there because they're not gonna hurt me. And the other part where they claimed I carried a solid rod where the ammunition go. I had 2 solid rods I had in there, and those I would put in my hand, and I wore
All right,
gloves.
Mr. Smith. Mr. Smith,
So
thank
that's
you.
why I had my belt.
All right, thank you. Mr. Bain, do you have other questions?
So, Mr. Smith, when you walked into a local government agency wearing a gold badge that allegedly says security with a pair of handcuffs and a patch,
I don't wear a patch, sir. I don't have patches on my shirt. I just got a patch on my hat.
So they
and
were
my
gold
shirt.
bars. My mistake. They were gold bars, evidently. And they
Because
were.
I was captain. I was
They're-
captain. Yeah,
Right.
I had other agents under me.
I understand. And that was in Florida, correct? Not Tennessee.
Sir. Yes, sir.
Thank you. No further questions.
All right.
This
Any
is
other
Walt
board members?
Valentine. I did have a question. Were you a licensed paralegal in Florida?
Yes, sir. Through my boss.
So you had a license from the state of Florida as a paralegal?
Yes, sir.
Okay. Are you a licensed paralegal in Tennessee?
No, I didn't go to school here in Tennessee. What do you mean licensed paralegal? Wherever you go from that time on.
I just
you're a
asked the
paralegal.
question, were you a licensed paralegal in Tennessee?
Commissioner Valentine, they're not required to be
Yes or no?
licensed as a paralegal.
Thank you.
Would
I am a
your
paralegal.
job?
I'm not a licensed paralegal in Tennessee.
Okay.
I never said I was a paralegal. I said I'm in school for that in Florida.
Thank you, Mr. Smith.
Okay. Your main job is just obtaining records, interviewing witnesses, and videoing them?
Yes, sir.
Okay.
And taking pictures of whatever I need to take pictures of, wherever it happened or whatever they need pictures, so the lawyer can have it for presentation in a hearing or a trial.
Okay. No further questions, Your Honor.
Your Honor, this is Commissioner
Other
Brown.
board members have questions?
Yes, sir.
Oh, excuse me, David Brown.
Your Honor, is
Mr.
it
Brown, activate
permissible to?
your-
Am I not
You can turn
activated?
your video on.
No, I'm Paul David Brown up here. Did y'all see it?
Yeah, I
I
see.
got a backup. I got a backup because my internet. We're in a rural area where I live.
Yeah.
Is it permissible to inquire about this aggravated perjury conviction, Your Honor?
No, sir.
Okay.
Anything else?
I have no further questions, Your Honor.
Other board members? All right, thank you. Mr. Smith, does that conclude your presentation of proof?
Yes, sir.
Mr. Gentry, does it conclude your presentation of proof?
Yes, Your Honor.
And we're ready to move into the next phase where I will charge the commission and will permit the closing arguments. Is there a need for a comfort break before we move into any of this?
See some head nodding, Your Honor, and I would
Yes.
agree with it if possible.
Yeah, everybody telling you, yeah, it's a comfort break.
Yeah, it is 12:41. We can take like a 30-minute break that can serve also as lunch. If that's needed, I hear a few people disagreeing.
See 5 minutes.
5 minutes.
5 minutes.
All right, is 5 minutes sufficient?
Yep.
Yes, Your Honor.
That's fine with me.
All right. We'll stretch it just a little bit. It's 12:42. We'll resume in 8 minutes. That'll be at 12:50.
Thank you.
Mr. Smith, are you present?
Okay. I'm back.
Mr. Valentine, is your board complete? Sorry, I can't hear you.
I'm sorry. Yes, sir. I think we're all present again.
All right, we're going to begin closing arguments in a moment, and then I'll issue a charge. The board's deliberation will follow. Our court reporter, Ms. Ailes, has asked me to remind the board at any time during your deliberation that you're going to make a comment. Please start that comment with your name. There are several of you. It's difficult for her to keep up with unless you identify yourself. All right, we're ready for the closing arguments. Mr. Gentry, you'll go first. Mr. Smith, you'll have an opportunity after that.
Excuse me,
Mr. Gentry? Yes,
that audio is being interrupted.
and everyone place themselves on mute unless they're speaking. That may help.
I could not understand.
I don't know who's speaking. Somebody is ambient noise, and one of them is all the. All
I'm
right.
sorry, Your Honor. I
Mr. Gentry?
just your voice was sound like it was double audio or feedback. I will mute.
Thank you. Mr. Gentry, go ahead.
All right, thank you. I think, I explained in my opening argument or my opening statement that the reason we're here today is whether or not Reese Smith and his business, Justice Now Press Civil Rights, engaged in unlicensed activity by Mr. Smith working as a private investigator without a license, and his company, Justice Now Press Civil Rights, operating without a private investigation company license. If you look specifically at the statutes for the definition of a private investigation company and a private investigator found in Tennessee Code Annotated 62-26-202, the definition of an investigation company means any person who engages in the business or accepts employment to obtain or furnish information with reference to crime or wrongs done or threatened against the United States or any state territory of the United States, the identity, habits, conduct, business, occupation, honesty, integrity, credibility, knowledge, trustworthiness, efficiency, loyalty, activity, movement, whereabouts, affiliations, associations, transactions, acts, reputations, or character of any person. And then there's a few other definitions that are not relevant, but then the last one, it's a business who works to secure evidence to be used in any court, board, commission, officer, or investigating committee. And then the statute also defines a private investigator as any person who performs one or more of those services described of a private investigation company. Anyone who operates as a private investigator without a license is subject to penalties from the commission, and anyone who operates a private investigation company without licensure from the commission is guilty of committing these violations. I believe Commissioner Bain had asked a few questions related to one of the exemptions from licensure about whether or not if someone is working as an employee of an attorney or how many attorneys that Mr. Smith had worked for. That exemption, I do not believe would apply. It specifically states that someone would be exempt if they were an employee of an attorney or of a law firm. We know that Justice Now Press Civil Rights is not a law firm. We know Mr. Smith had stated he did not work as an employee of these law firms. He stated he works for these families. So that's who his client is. I think from his testimony, it's very clear. He's been in operation since the year 2000 in the state of Tennessee. He stated that he's done a lot of investigations over those years, but he's even currently working multiple investigations at this time. The work that he's doing, stating that he collects documents, he interviews witnesses, testifies in court, he provides this information then to these individuals who he's working for. I think that that is all work of a private investigation company under that statute, because he is in the process of collecting evidence for a court hearing, which is what it states. He's securing evidence to be used before any court. No one here is stating that what he's doing, that he's committing all these violations because he's hurting people or hurting the public. But what we are here is to look at specifically, did he have a license? Did he need a license? The answer from his testimony, as well as from Director Vest, we know that he does not have a license. Now, the commission needs to decide whether or not he needed a license. I believe from his statements and the work that he does, he clearly fits in this definition in terms of being a private investigator, and that his company is a private investigation company. He says he's been in business for several years. I know he's trying to make a distinction that he has a power of attorney, but there's not an exemption in the statute for someone who's a private attorney. It says, is it a person doing this work? And we know that Mr. Smith is doing this. We know that his business is doing this. So that does subject him to penalties of up to $2,000 per violation. And then it also subjects him to court costs and investigatory costs for these activities. The penalties could be up to $2,000 per violation, as I stated. So potentially up to $4,000 total for acting as a private investigator without a license, and for acting as a private investigation company without a license. I don't know if the board or the commission has the discretion to make that determination. I think from his testimony, and we don't have people coming here and saying how they've been wronged by him or hurt by him necessarily. And I think from his testimony, he did state that he is helping people. So I think that is something the commission could take into consideration when deciding on how much of a penalty would be appropriate. But we have this licensing, the commission has this licensing authority. The state decided that individuals doing this type of work needed a license. And I think that public policy would state that we should make sure that the integrity of these licenses are upkept by the commission, that individuals who are acting without a license, even if they're not necessarily committing acts that are directly hurting someone, that it does hurt the rest of the individuals who have had to go through the hoops, who have had to make sure they're licensed. And it hurts the integrity because other individuals could see that the state is not enforcing its licensing requirements, and that they may be more nefarious and may not get those licenses as well. So I think that there's justification under that public policy for that reason. And I think for those reasons that the commission should find both that Mr. Smith was acting as a private investigator and his company was acting as a private investigation company and is subject to penalties from this commission. Thank you.
Mr. Smith, do you want to make your closing statement now?
Hey, Your Honor, Mr. Gentry keep bringing up private investigator. Sir, number one, if I was breaking any law or broken any law, believe me, when I spoke to grand juries or sat in grand juries, I'm quite sure somebody would have arrested me for acting as inappropriate, something that I'm not, which is something that I am. I am a licensed pastor. I do help families. I am a licensed civil rights. I help family members, work in the family members, and I work in the sector of the families where a lot of families don't have help. A lot of them don't have money to fight for their rights when they go to court. So they come to me to ask me how to help them, and I teach them. I do seminars and everything, so I don't never perpetrate myself as being a private investigator. I let everybody know who I am, what I do, and the reason why I do what I do. So Mr. Gentry keeps saying private investigator. I'm not a private investigator. I'm just a concerned pastor who helps family members who needs help. Now, if y'all are so concerned about what I'm doing, then you need to go collect the whole world, because there's a lot of people that are doing the kind of work I'm doing that's helping families who've been killed, murdered by police officers, who don't have help, who don't have an out, don't have nobody to help them, and that's what I do. So we sit up here trying to insinuate I'm acting as something that I'm not. No, I'm helping family members that I have knowledge of doing, that I was taught by a good lawyer who was good in criminal. And as long as he was alive, nobody said nothing to me, nobody touched me, it bothered me. But since he been dead, everybody wants to try to put me in a position that when he was living, we wore uniforms. We wore our badges to concern and satisfy who we are, who we work for, what we doing. Now that he's dead, now y'all want to sit up, now you want to come up. I've been here since 2000. I've been in the courthouses in Nashville, Clarksville, Springfield. I've been everywhere around Tennessee, been to Atlanta, been to Chattanooga. So now y'all sitting there trying to tell me that what I'm doing is breaking what law? I haven't broken the law. I haven't committed or done anything wrong but help people, because nobody should be going to prison for something they didn't do. And if we can help them, which I'm doing, because I don't want nobody to go to prison. That's a place no man should go to or be at. Y'all sitting here like y'all got freedom and y'all all right with it. Well, everybody ain't had freedom. Everybody ain't been free all their life. We all been behind bars, not for what we done, because people didn't like us or our color. Now y'all want to tell me, as a black man, I don't have any rights? But when my boss was living, nobody said nothing. I had all kinds of rights. I walked hard, did what I done, and did what I had to do. Now y'all want to sit there and question my ability, what I know, and how I help people? And Mr. Gentry now trying to stick to this private investigator. Private investigator. I'm not a private investigator. I'm a licensed pastor, and what I was taught was by my boss, who taught me everything I know today. So if y'all want to penalize me for being taught how to help people, how to help families, and then you want to look at me as being a black man like I don't have any right to do what I'm doing, I have more rights to do what I'm doing and helping folks. And as long as I got breath in my body, I'm going to keep helping people, because I'm not doing anything wrong. So if you want to penalize me, but you're not going to stop me. You're not going to get in me, because you do not have jurisdiction over me. What I'm doing, I have the right to do. It ain't like I'm walking out here doing what I want to do. I've been on Facebook ever since Facebook started. I've been dealing with people on Facebook, talking to people on Facebook. I've been telling them where to go, how to research, how to get the information, how to prepare the cases, and how to be prepared to go to court. And the reason why they won, because they listened and they followed my path, they followed me, and they followed how I told them how to do. Because lawyers today don't give a damn about these people. Because they're not Ben Matlock, they're not Perry Mason. So these people are being in prison for what? They don't have the knowledge to know what to do for themselves. So I'm there to help them. So y'all want to penalize me for being somebody that these people need, penalize me, but you're not going to stop me. You want to charge me a fee? You want me to pay a debt, pay a bill? I'm going to do what I have to do. But I don't make money from these families, because I'm out here helping these families. They don't have money to pay first. But wherever I got to go, they take care of my expenses so I can go take care of what they need. So if y'all want to penalize me for being what I am for the people out there, then penalize me. I'm disabled. I don't have any money to pay out nothing. I'm just doing the best I can to keep other families home. So sons have fathers and daughters have mothers. And if that's hard for y'all to understand, then I don't know what else to tell y'all. But judge me not, because you will be judged. I never said I was a paralegal. I never said anything like that. I said I'm an agent who works for the families who help them because of me. Because of me going to prison for something I didn't do. I'm a free man. If I can help other families stay free, I'm gonna keep doing it. So y'all want to penalize me because I have a heart for people and I have love for freedom, something that God gave me, then y'all do what y'all gotta do. But I haven't done anything wrong, but help sons and daughters have a mother and father at home so they can have a house and not in the street trying to find a place to eat. So I am sorry that I'm not what y'all want me to be to y'all. But I never said I was a private investigator, never acted out to be one. But Mr. Gentry keep trying to put on private investigator. I'm not. But if y'all feel that y'all need to penalize me for doing right for families, helping children have their mother and father's home, then y'all do what y'all got to do. Because I'm not going to argue with you. I'm not going to.
Does that conclude
I will file my appeal, though. I will appeal whatever decision y'all make, because this is not right. And
Does that
then
conclude
look at your board.
closing statement?
Excuse me?
Does that conclude your closing argument?
Yes, sir.
All right. It is now my responsibility to charge the commission. The commission has heard proof in the matter of Reese Smith, DBA Justice Now Press Civil Rights in docket number 12.32-204632A. You are the exclusive judges of the facts in this case. You're also the exclusive judges of the law, specifically your statutes, the rules and regulations, and their application to the evidence you've heard in this case. You should apply the law to the facts in deciding this case under the directions of my charge. You exclusively have the authority to make findings of fact and to reach conclusions of law in this matter. No one else can participate in your deliberations. However, if you find you have a need to have the law or legal terminology explained to you, I can assist. The state has alleged that the respondent has violated certain applicable statutes. It is the state's burden to prove those allegations by preponderance of the evidence. That's not to be confused with the higher standard of beyond a reasonable doubt. A preponderance of the evidence, which means greater weight of evidence, or that there is sufficient proven information for you to believe that the state's allegations are more probable, or the more probable conclusion based. Are you interrupting me? Who's trying to speak? All right, if you're not speaking, if there's not something to come up, then please mute your microphones. So the preponderance of evidence, as I was saying, means the greater weight of evidence, or that there is sufficient proven information to cause you to believe that the state's allegations provide the more probable conclusion based on all of the evidence presented. You must limit your inquiry into the violations of the rules or statutes to those that were specifically alleged in the notice of charges. And specifically, the commission must determine whether the acts proven by the state to have been taken by the respondent or his admissions of acts taken by the respondent constitute the acts of an investigations company or a private investigator subjecting the respondent to the requirements of Tennessee Code annotated 62-26-204, and if so, under the totality of circumstances, whether any discipline under 26-217 is warranted. In reviewing those statutes, the definition portion that has been alluded to for investigation companies is found in 62-26-202, subsection 6 says an investigation company means any person who engages in business or accepts employment to obtain or furnish certain information as indicated. So the first element is engaging in business or accepting employment. The private investigator means a person who has performed one or more of the services that are enumerated in section 6. You must base your determination solely on the evidence that was presented to you. You must not infer from any of my rulings or instructions that I hold any view or opinion for or against any party. None of my remarks have been intended to indicate an opinion as to the facts or what your decision should be. If these instructions contain repetition, it is for clarity and not special emphasis. You're not supposed to single out a certain sentence or individual point or instruction and ignore the others, but you are to regard each in light of the others in order, the order in which the instructions are given does not signify their relative importance. The evidence consists of the testimony given by witnesses during the hearing and the exhibits that were introduced into evidence, which you may review during your deliberation, any facts which may have been stipulated to by the parties, the statements and arguments by the attorneys, and for Mr. Smith during his opening statement or closing argument, do not constitute evidence, as the technical record does not. And so you may use those arguments that were made to assist you in making your findings of fact and conclusions of law, but you should do so only after careful consideration and determination that they accurately reflect your own independent recollection of the evidence and your own conclusions from the evidence. The law requires your decision to be made solely upon the competent evidence before you. Evidence that has been excluded from your consideration was excluded because it was not legally admissible, and you must assume that it has no value to you in reaching your decision. Whenever evidence was limited or admitted for a limited purpose, you must not consider it for any other purpose. The evidence, there are basically two kinds, direct and circumstantial. Direct evidence is proof of a fact, such as testimony of a witness about what the witness personally observed. Circumstantial evidence is indirect evidence that gives you clues about what happened. Circumstantial evidence is proof of a fact or a group of facts that cause you to conclude that another fact exists. It's for you to decide whether the fact has been proven by circumstantial evidence. And if you base your decision on circumstantial evidence, you must be convinced that the conclusion you reach is more probable than any other example, or excuse me, any other explanation. For example, a witness who testified that they saw it raining outside would be an example of direct evidence that it's raining. If the witness testified that they saw someone enter a room wearing a raincoat covered with drops of water and carrying a wet umbrella, that would be circumstantial evidence from which you could conclude that it is raining. You are to consider both direct and circumstantial evidence. The law permits you to give equal weight to both, but it is for you to decide how much weight to give. In making your decision, you must consider all of the evidence in light of your reason, experience, and common sense. You are also the sole judges of credibility or believability of the witnesses who have testified. You must decide which witnesses you believe and how important you think their testimony is. There is no fixed set of rules for you to use in deciding whether you believe a witness, but it may help you to think about questions such as their ability to see, hear, or be aware of things, that how well the witness was able to recall or describe those things, how long they might have been exposed to the information they're testifying about, and whether or not it appears they have a good memory. In making your findings, the commission must make the sole determination about the credibility and weight to be given to the evidence presented by each witness. If there's a conflict in the testimony between witnesses, it's the responsibility of the commission to reconcile those conflicts. But if it is impossible to reconcile the conflicts between the witnesses, the commission must make a determination as to which witness to give the most credibility. The law presumes that all witnesses who are sworn will testify truthfully. It is the obligation of the finder of fact to attempt to reconcile any discrepancies in the testimony. But again, if it's impossible, it's necessary for the triers of fact to determine which witness speaks the truth and which witness has stated a falsehood despite their oath. In determining which witness is believable, the commission, as the fact finder, has wide discretion. However, the commission should consider in determining the truth the witness' interest, if any, in the outcome of the matter, their good intentions, their seeming honesty, their respective opportunities for personal knowledge of the facts of which they are testifying. Although you must consider all of the evidence, you're not required to accept all of the evidence as true or accurate. You should not decide an issue simply by the process of counting the number of witnesses who have testified on each side. You must consider all of the evidence in the case. You may decide that the testimony of fewer witnesses on one side is more convincing than the testimony of witnesses on the other side. There may have been discrepancies or differences within a witness's testimony or between the testimony of different witnesses. This does not necessarily mean that a witness should be disbelieved. Sometimes when two people observe an event, they will see it or hear it or recall it differently. Sometimes it may be just an innocent lapse of memory. The witness may testify honestly, but simply be wrong about what they thought they saw or what they remembered. You should consider whether the discrepancy relates to an important fact or only an unimportant detail. The state has charged the respondent with certain violations of the statutes. For each of these charges, you have to determine whether the alleged violation has been proven by preponderance of the evidence and specify in the findings of fact portion of your order the specific underlying facts that support your decision. In making your determinations, it may be necessary for you to interpret the statutes and rules. When the language of the statute or rule is plain, you have to follow the plain meaning. However, if it is ambiguous, you may give your interpretation of the language so as to explain the conclusion you reach as to whether there was a violation as charged. If in your deliberations you find that one of your statutes or rules is ambiguous or you are uncertain as to how to interpret it, please let me know and I'll give you more detailed charge on statutory construction. The final order that you must develop has certain contents that are required. The Administrative Procedures Act specifically requires that your order contain 4 sections: findings of fact, conclusions of law, a decision regarding what disciplinary action, if any, should be taken, and a policy reason for your determination. In the findings of fact, you make your own evaluation of the testimony given by each of the witnesses and any documentary evidence, and then you must give the testimony or evidence the proper weight and credibility that you deem it to have, and record in your order in the findings of fact those facts that are relevant to the issues being determined and that support the conclusion you make. Once you've made your findings of fact, you have to decide whether the respondent's activity constitutes a violation of the statute as alleged in the notice of charges. You must state those determinations in your conclusions of law. Your decision must include sufficient analysis of the evidence to clearly demonstrate how the facts that you found support your conclusions. Your conclusions of law should make appropriate specific references to your findings of fact to articulate the link or connections between the 2 sections. If you decide there's been a violation, then you must decide what disciplinary action is appropriate in accordance with your legal authority, considering the particular circumstances of this case. You may consider that the parties have introduced, you may consider any evidence that the parties have introduced on the issue of appropriate disciplinary action, including whether the conduct alleged was of a continuing nature or a one-time offense, or the harm, if any, that was caused. Additionally, you may also consider what you've done in similar previous cases. Under the law, the agencies aren't required to have absolute consistency in the disciplinary action they take. However, this does not mean that you may be arbitrary or capricious in dealing out disciplinary actions. The disciplinary actions must be based on fairness and reason. And the policy reason must accompany your determination to state why the decision you rendered in this situation is appropriate. All right, Mr. Chairman, at this time, I'm going to turn this matter over to you for your preliminary discussions, after which, if you request, we can hold the parties if they have prepared any sort of proposed findings of fact or conclusions of law to help guide your discussions. Mr. Valentine, the floor is yours. I believe you're still on mute.
Fellow board members, any discussion on this finding of fact?
Mr. Chairman?
Yes.
I think what Mr. Smith has been doing is very honorable. However, out of his own definition of what he does, he has been investigating and acting as a uh, witness in cases of not being properly licensed in the state of Tennessee. And I attribute that to be as if I have a driver's license for South Carolina and I live in Tennessee and I have not, over the correct period of time by Tennessee law, transferred and gotten myself properly licensed in Tennessee. I have, even though my intentions are good, uh, I have violated Tennessee law. Again, I commend Mr. Smith for what he's doing, but uh, it does not look like he needs some assistance and getting properly licensed with the state of Tennessee to do what he does. So based upon what I've heard listening to this, it's my opinion that Mr. Reese has violated the statutes of Tennessee codes.
Okay. Any other board members have an opinion or a thought on the finding of fact?
It would be good to hear from others. I have been over and back on the statutes and 13 pages of notes, and while I agree with Mr. Russo, agree with those that reviewed. Honorable, yes. Mr. Reeves, necessary, yes. And yet, by a preponderance of information that I'm hearing, the work he does consideration of what is provided to attorneys what can fits the statement in the statute that says the securing of evidence to be used before any court, board, commission, officer, or investigating committee. Must concur with Mr. Russo.
I'm going to ask if anyone else is having some difficulty with the audio portion. I don't know if it's a local problem I'm having or if it's systemic. I see. All right, Ms. Ailes, were you able to get all of the comments of Commissioner Bain?
I was, Your Honor, but I am seeing some of the yellow triangles coming up on some of the other commission members.
Yes. I don't know if it's atmospheric conditions or some other ethereal thing, but I'll, as long as Ms. Ailes got all of the statements, I'll ask for other commissioners then to speak. I see Mr. Valentine's got his yellow triangle up, so let's just be careful to make sure we get a record completed. Any other preliminary statements from any of the other commissioners? Mr. Valentine, are you with us? Mr. Valentine, are you with us? Does anyone have the ability to communicate with Mr. Valentine to see if he is going to sign back on?
Shauna, can you send him an email, or Shauna is one of our administrative staff. She could reach out to him, Your Honor.
This is Charlie Bradley. Chairman Valentine advised he's frozen up right now.
All right, Mr. Smith, did you prepare a proposed findings of fact or conclusions of law document? You're on mute, sir.
Can you hear me?
Now I can.
Okay. It was, I didn't know. Okay. Now he was asking if I prepared to do it now.
Did you prepare a document called Proposed Findings of Fact and Conclusions of Law?
Oh, no, sir.
All right. Mr. Gentry, did you prepare such a document?
I did, Your Honor.
All right. As soon as Mr. Valentine rejoins us, we'll see if he wants that document submitted to guide the discussions.
This is Cody Vesta, Director. I have contacted Mr. Valentine and he's trying to reconnect.
It's not a unusual circumstance in these technological proceedings.
He's back.
Right.
All right, Mr. Valentine.
Sorry about that, Judge.
That's quite all right. We've ascertained that Mr. Smith has not prepared a proposed findings of fact or conclusions of law. However, Mr. Gentry has. Do you want a copy of that document shared to guide your discussions, or are you prepared to go forward without it?
I think we're prepared to go forward, Your Honor.
All right.
I'm sorry, Your Honor, I'm having a hard time hearing Mr. Valentine. If he could turn his microphone up.
Okay. Can you hear me now?
It's very low volume.
Okay.
Are you using your computer for
Yes.
audio?
Yes.
Check and see if it's turned up as high as it'll go. The microphone.
It is turned up as high as it'll go.
All right.
Okay. Can you hear me now?
Yes, sir. It's still diminished from your previous volume, but I think if you're careful, we'll get everything.
Okay. Any other comments or on the finding of fact? Hearing none, Mr. Gentry, would you read your finding of fact?
I guess I need clarification. Your Honor, do you want me to send the proposed findings of fact then to the commission members?
Yes. Mr. Valentine, you're wanting to see the proposed findings of fact to guide your discussion?
Yes.
Okay.
All right.
we'll have that sent into the commission members, and then would you like a copy? And normally when we're in person, we're handing that to the judge and the respondent. So Your Honor, do you want me to email a copy to you and to Mr. Smith separately?
That's fine.
Okay. Perfect. Then Carol McGlynn and Shauna, if you all could get a copy of that email to the commission members, I will make sure that I will send a copy then to the judge and to Mr. Smith.
Okay, I've received the proposed finding of fact.
Well, Mr. Valentine, as chairman, you direct this deliberation process.
Okay. Has everyone received a copy of the proposed finding of fact? And if so, do I have a recommendation from anyone?
I've just received it just now. Please allow me to read it.
Okay. There are 16 different points. Finding of fact. Proposed finding of fact, I'm sorry.
Commissioner Valentine,
Yes.
I review it and I concur with it.
You need to state your name before you speak so that our court reporter can keep up with it.
Sorry, Your Honor, Commissioner Brown.
Anyone else finished reading it? Have any comments?
This is Alan Russo. I concur with the proposed finding of facts.
Thank you, Mr. Russo.
This is Mr. Bain. I concur with the proposed finding of fact.
Commissioner Johnston, I concur.
Thank you.
Commissioner Shanks concurs.
Charles Bradley concur.
Okay. Judge, we have a unanimous decision, the 16 counts of finding of facts. We concur with 16 that are listed.
All right, sir. Are there additional findings of fact that the commission wishes to add to any of the 16 that are listed?
Any response to that?
Yes. One, this is almost a question, Walt. Respondent does not believe respondent is serving as an investigator, evaluating the truth, validity of people. Period.
Interviewing witnesses and providing video and taking photographs.
Yes, respondent does not believe that these constitute investigatory activities.
Okay, we would like to add that to the 16 then?
If that is deemed acceptable to the commission, yes.
Yes, Commissioner, you need to poll the other commission members. You need a majority vote to take an action.
Okay. Mr. Bain concurs. Mr. Rousseau.
I do, sir.
Alan Russo, I concur.
Okay.
Robin Johnston, I concur.
Mr. Brown.
Charles Bradley concur.
I concur with the amendment.
Commissioner Shanks concurs.
Okay. And Commissioner Valentine concurs. So we will add a 17th that respondent did not believe his actions of interviewing witnesses, obtaining video and photographs, and what was it you said, Stuart?
Respondent believes he did not engage in investigatory activities.
If we may combine those two sentences.
Yes, sir. Please, sir.
Okay. Judge, that concludes our finding of fact.
Very well, you can move to the conclusions of law.
Okay. Board members, if you would review the proposed conclusions of law and determine if you have any additional comments or additional conclusions. There are 7 conclusions of
Mr.
law.
Mr. Russo seems to have indicated he had something to add.
Okay, Mr. Russo?
Would it, some clarification, would it be appropriate to add in our conclusions that Mr. Smith should pursue the proper licensing for the things that he does in the state of Tennessee?
Mr. Russo, as you state that comment, it would be more appropriate in your judgment section or in explaining the action that you would take based on your conclusions of law. I mean, I'm not trying to invalidate the statement. I'm just saying that there may be a better place for it in the order.
Okay. Other than the 7 proposed conclusions of law, anything else that any board member?
Commissioner Brown, there's a typo. That 7th point is number 4 on what I'm looking at.
Right.
That needs to be corrected.
We will change that 4 to a 7 on last conclusion of law.
And in the second item, the word investigation as a apostrophe S, when in fact it could simply be investigations or investigation. That's simply editorial.
Any other comments or corrections or additions? Hearing none, call the roll to approve the 7 proposed conclusions of law. Stuart Bain,
Aye.
David Brown,
I concur.
Robin Johnston,
Aye.
Alan Russo,
Aye.
Doug Shanks,
Aye.
Kendall Barham,
Aye.
Charles Bradley,
Aye.
and Walt Valentine. Aye. Judge, we have 7 proposed conclusions of law that we have approved. Now we go to the proposed judgment.
Just as a point of clarification, once you've discussed it, this becomes the judgment, not a proposed judgment.
Okay. Thank you.
I will step out there. Bain, the work Mr. Smith does is honorable, needed, and while Mr. Smith has demonstrated what he believes to be non-investigatory work, I continue to conclude as a judgment that he should be assessed $50 in civil penalties.
Instead of the 500?
That is correct.
Russo, I concur.
Have a motion and a second to change the $500 civil penalties to $50. We would need to correct a statement under that. Mr. Bain, $25 for each violation instead of $250?
Yes, and I must ask for clarification on what item 2 is about. remaining, what kind of costs have been incurred?
Hearing costs of us today, Judge?
I will, I'll try to clarify that point. The statute permits the commission to recover costs of their investigation, including their investigator, all of the hearing costs, which would include the charges from the Administrative Procedures Division, all of the time in setting this up, the hearing itself, but those are in the discretion of the commission. You can award costs. You can, you can impose the costs or not impose the costs, or you can impose a limited amount. You have complete discretion on whether, and if so, how much of the cost you would assess or impose against Mr. Smith.
I will jump in there on the record. Bain again. I believe that given the work, the intentions, the effort, that very minimal costs be incurred. And thirdly, Mr. Smith should be, my judgment would be Mr. Smith is hereby ordered to get himself a PI license.
If he can.
Yeah, if he can.
I would like to amend that to say to the fill out the application and apply for a PI license.
I don't think that would come under judgment.
No.
Yes, actually, I think it will.
It will? Okay.
This is Commissioner Brown.
Yes.
I propose something different. I propose a $500 fine jointly, the $250 each, but then waive our cost. Because I think the costs are going to be substantial. And there's got to be some kind of a penalty. I emphasize with him, he's doing a tremendous job, but it's not like he's not aware of what the situation is and our requirements. But if we accept the $250 each and then waive our cost. Is that permissible, Your Honor?
Yes, we can do whatever we want to here.
Okay.
Okay, so talking about our judgment having number one only and not having number two?
No, just change number two to where the cost, the state eats the cost, not the respondent.
Or just say the respondent is not assessed.
However, whatever the legal language for it to be, that's going to be the greater cost.
I would suspect. Okay, any discussion on that motion?
Commissioner Valentine, can I get some clarification on what that wording would be, or some directive from our attorney? And
Okay, well, what we're proposing now is go with number one as it is written and insert the word not in number two. The respondent is not assessed prosecutorial, investigatory, and hearing costs incurred by the state herein.
It is not assessed any.
Right, not assessed any. Any comments on that?
Commissioner Johnston, I concur with Commissioner Brown.
Okay. Johnson and Brown. Bain?
I concur. I want to stress the mention of Mr. Smith is to make application for a PI license. That appears to be an item 3, I think.
Okay, item 3 then will be, Mr. Smith is,
You can say
Required.
that Mr. Smith is directed or strongly encouraged to file for a private investigator's license.
yes, directed to apply for a private investigation license.
If Mr. Smith is going to continue this work.
Yes.
Commissioner Shanks, hearing everything today, Mr. Smith started in Florida. He worked for an attorney in Florida. That attorney died, and I think Mr. Smith didn't realize he was working under the attorney's umbrella in Florida, and that's why he could do what he was doing in Florida. So also, if he's able to find an attorney to work for in Tennessee, I think he can go that avenue without getting his PI license. But I think where he's got confused, he didn't realize that the attorney in Florida was covering him so he didn't need to be a private investigator. I think that's just my opinion.
Mr. Chairman, would it be appropriate to add that to number 3? Ask, that either apply for a PI's license or seek affiliation with a law firm to continue his work.
That is a nice way of saying number 3. Okay. Does everybody concur in that? Mr. Bain?
I do, sir.
Mr. Brown?
Mr. Brown, you're on mute.
David Brown?
Try that again, Commissioner Brown. I concur. Mr. Smith, I would encourage you to get your license. You'd be an asset to our organization. We'd love to have you.
Robin Johnston?
I concur.
Alan Russo?
I concur.
Doug Shanks?
I concur.
Kendall Barham?
I concur.
Charles Bradley?
I concur.
And Walt Valentine concurs. That completes our judgment. Hunter, anything else we need to do?
Yes, sir. The board needs to deliberate on and propose a policy statement that supports your determination. You have the findings of fact, conclusions of law, the judgment, and the 4th element of the order is the policy statement.
Not exactly sure what you're asking for there, sir.
The policy statements that I have seen and I could share with you as an example are things like the determination of the commission is made in order to support the enforcement of the statutes regarding private investigations, companies and private investigators. It just something that's short that says that your intention is that supports your determination.
Okay.
If you want me to pull up other orders.
Okay, a policy statement then would be the Private Investigation and Polygraph Commission has determined that for deliberation above, is to enforce the Tennessee Code as it relates to the private investigation and polygraph rules and regulations and laws.
If your commission concurs with that phrasing, then that would be an appropriate policy statement.
Okay. Any discussion on that particular statement? Hearing none, we will call the roll. Stuart Bain,
Aye.
David Brown,
Aye.
Robin Johnston,
Aye.
Alan Russo,
Mr. Russo, you appear to be on mute.
Sorry. Aye.
Doug Shanks,
Aye.
Kendall Barham,
Aye.
Charles Bradley,
Aye.
Walt Valentine concurs. Anything further, Your Honor?
It appears that the commission's completed its work in deliberating and formulating this order. I would want to take the opportunity to express my appreciation for the board's attention to this matter, for Mr. Gentry's presentation, as well as Mr. Smith's. I know that there were a number of witnesses who are not present. All of the participation of persons fulfilling their particular roles in this have led to the conclusion that I think speaks well for everybody's effort. I want to express that while we're on the record, but I have nothing further. If that concludes the board's business for today, Mr. Commissioner, you can dismiss the hearing.
Thank you, sir. This hearing is dismissed. Concluded.
Your Honor, Mr. Chairman, this is Lance Baker, City Attorney for City of Clarksville. The city would like to order a copy of the transcript, please. Is the court reporter still online?
You need to communicate with Mr. Gentry to see about deferral of any costs on that. These were incurred by the Department of Commerce and Insurance regulatory boards, so you can communicate directly with him.
Thank you, Your Honor.
Mm-hmm.
Mr. Gentry, you gonna send me a copy of everything today?
I will send you a copy of the order, yes.
Good.
And commission members, I would like to thank each of you for being with us this morning for the board hearing and for this commission hearing. Thank you very much.
Alan and Walt's been a long ride, but it's been fun.
Hope to see you soon.
Yes.
All right.
Thank you, everyone.